Good morning and welcome to the 25th meeting of the Equalities and Human Rights Committee. Our first item is to consider whether to take item 4, consideration of correspondence from the Finance and Constitution Committee in private. Are members agreed? Members are in agreement. Our second item of business is our third evidence session on the United Nations Convention on the Right of the Child Incorporation Scotland Bill, UNCRC Bill. We'll hear from 2 witness panels this morning, and I'm grateful to all witnesses for their attendance. Can I welcome witnesses on our first panel, Juliet Harris, Together, Scottish Alliance for Children's Rights, Carly Elliott, Policy Manager, Who Cares Scotland, Josh Kennedy, MSYP, Scottish Youth Parliament, and Kevin Kane, Policy and Research Manager at YouthLink Scotland. Thank you all for being with us this morning. We'll move to questions shortly. If I can just remind members that if your question is addressed to a specific witness, please identify that witness by name. Otherwise, we'll work to the order in which I've just named the witnesses. Witnesses, if you feel you have nothing to add in response to a question, please don't feel you have to speak. You can simply state so, and we'll move on. We've quite a lot to get through today with a limited amount of time, and I appreciate we're working with technology as well as scrutinising the bill. So I'd encourage members and witnesses to keep questions and answers as succinct as possible. And just a reminder to allow broadcasting staff a few seconds to operate your microphones before beginning a question or providing an answer. So if I may start, there's strong support for direct incorporation of UNCRC into Scots law, and the committee heard last week that this bill is unique in international terms. As well as directly incorporating the UNCRC, it includes active and reactive measures. Can I ask panel members' views on the Scottish Government taking this approach? And we'd be interested to hear your reflections on the possible benefits or disadvantages. And if I could pose that question to Juliet first, please.
Thank you, Convener, and thank you, committee members, for inviting me to give evidence on the UNCRC Incorporation Bill. As you know, we've been campaigning for years, for decades, for full and direct incorporation of the UNCRC into law. And as the Children's Commissioner said, it's the number one thing that we can do to make sure that children's rights are at the centre of everything that we do. In terms of the benefits of full and direct incorporation, I just kind of like to look back to 2013 when I was giving evidence on the Children and Young People Scotland Act. And back then we were talking about the fact that the very process of incorporation brings about a culture change in which children and young people are better recognised as rights holders. And that was 2013, 7 years on, we're living that culture change. It's happening right now. You as committee members have been part of it. And it's an extremely strong bill. It's been drafted in a way that is so inclusive. The drafters have listened to children and young people who said, we want full and direct incorporation because we want to know that the rights are the same rights as those that are in the UN Convention on the Rights of the Child, the same rights that other children right across the world also enjoy. So from education, health, social work, through to transport, policing, the environment, full and direct incorporation provides that clarity that children and young people have the rights that are in the UNCRC, and that these rights are something that we don't just need to think about, but something that we embed in everything that we do. So that's the benefits of full and direct incorporation. I really don't think there are any failures to this approach. It really is what children and young people have asked for. They've asked for a binding duty, that's in the bill. They've asked for access to remedy and redress if their rights are breached, that's in the bill. Obviously, we'll find areas where there can be improvements. We'd like to talk today about the interpretation clauses, definitions of public authorities, better access to justice, and particularly commencement. But this is an extremely strong bill, and we're living this culture change that full and direct incorporation brings.
Thank you, Julia, and I know colleagues will come to Carly, can I ask for your response to that question, please, about the benefits and any potential disadvantage?
Yeah, thank you so much. Who Cares Scotland is incredibly supportive of the bill, and we're really excited that Scotland is in the place that it is with incorporating the UNCRC. As an organisation that's provided independent advocacy for over 40 years, we're all too aware of the challenges that care experienced children and young people can face in navigating the world of their rights, and we firmly believe that this bill, as it stands, is already a really good attempt at being able to rectify that challenge that they face. The bill is full of advantages. It's yet too many to go through. I think you named it yourself, convener, when you said it takes both proactive and reactive measures. And I think that full spectrum of access to justice and information options will be the thing that makes this different day to day for children and young people, and that's really, really exciting. In terms of areas that the bill, there are no disadvantages, just to make that very clear, but there are areas that we think could be strengthened, and that's particularly in relation to the Children's Rights Scheme and the Public Authority Reporting Duty, both of which are incredibly important but could probably benefit from just a few additions. And just to briefly run through what they are, and we'll expand on them later, I'm sure.
Kylie, sorry, Kylie, I'll pause you there because I know that colleagues will want to probe on the specifics of that, so we will come back to that, I promise. Josh, can I ask for your reflections on that one question, incorporation, please?
Yes, well, thank you for having us all along today. Just to echo that, SYP has obviously been campaigning on this issue for quite a while. In fact, in our Lead the Way manifesto from 2016 to 21, we saw an overwhelming 76% of young people before this was even an issue in the mainstream, agreeing that the UNCRC should be fully and directly incorporated into Scots law, and that the rights of young people and children should be protected and promoted. So we're really happy that there's been a positive step in this direction. We've also been consistently making calls in our Right Here, Right Now campaign, which ran from 2017 to 2018, and also at our children and young persons meetings with the Scottish Cabinet, where we outlined the importance of this full and direct incorporation. There's a few reasons why we made this call. Importantly, rewriting rights raises the risk of them being diluted, and this does not fit in line with the principles of full and direct incorporation. Obviously, UNCRC rights are universal and are all equal. Scotland can set a leading example to the world not to cherry pick which UNCRC rights should apply and which do not, keeping intact the principles of universality, indivisibility and interdependence on human rights, which we think is extremely important. The basic rights of children should be the same wherever they live in the world. As you'll be aware, Norway, Iceland and Sweden have all incorporated the UNCRC without difficulties in its interpretation. As an MSYP said, which I think cut through the argument, you can't pick and choose what rights to protect, as are all important. To do so could result in discrimination. This is obviously a real concern of our members and young people we've consulted across the country, as rights are in place to hold the government and key decision makers to account, as I'm sure you know. All rights are equally important. It's so important to stress that. It would be dangerous to permit decision makers and duty bearers to decide which rights will not bind them. This maximalist approach to incorporation highlights that the UNCR is the bedrock and baseline for children's rights and young people. Article 41 of the Convention underpins this fact. Importantly, encouragingly, we can build on this and place a higher standard of rights protections. Direct incorporation would not hinder the government to go further, and this is a good thing. This direct incorporation will allow Scotland to keep pace and adapt to an international level developments, and as we will later look at, taking into account of general comments of the UN, which can inform a better approach. By incorporating the UNCRC, we ensure that these children, including vulnerable situations who live here and yet may not have Scottish nationality, are included also. It's so important that this group can access these new protections. Finally, I also think it's worth mentioning Brexit, as the UK is speeding towards our exit from the EU, as well as the risk of further austerity due to strains from the COVID-19 pandemic, putting rights at risk in Scotland. Direct incorporation is the best way to address this and ensure that Scotland can really be the best place to grow up in the world. Thank you.
Thank you. Kevin, if I could come to you now, please.
Thanks, Ruth. That was all excellent stuff from everyone. So on the overarching stuff, I'll leave that well alone and maybe focus on the two-pronged approach in the bill around the proactive cultural shift, which is really positive on children's rights, and the reactive commitment to protection when a child's rights have been breached. On the first point on the proactive elements, our sector is cited because we're position to inform and enable other services that are built around children and young people. So this will help everyone get policy and law fit for purpose at the earliest possible stage. As an educational practice, what really excites us is the chance to bring about the positive cultural change that we often talk about. We're so fortunate in the youth work sector that we're in schools and we're in communities. We're in the unique position that we take a non-formal approach for young people, and that substantially increases the reach of our sector. At the reactive end, we're keen to explore how youth workers can develop their existing approaches to ensure that young people have access to remedy and redress, and in the most serious breaches, we stand ready to provide child-friendly advice and advocacy, particularly for those people who face additional barriers in pursuing remedies. More broadly, we've heard from thousands of children and young people at every phase of this consultation. They've driven the campaign to where it is today. They tell us that they want it. Representatives from other countries tell us how it's changed, how children see themselves, which is brilliant. And we know from international precedent that with incorporation, children's views are better considered at every level of decision and policy planning. So in closing, we are on the cusp of something special. Therefore, it's incumbent on everyone here to get passage, commencement, implementation and the support and guidance correct on this bill from the get-go.
Thank you, that's helpful. So, I mean, clearly we're living in quite challenging times, and the pandemic has highlighted existing inequalities, particularly for disabled children, minority and ethnic people, children and young people in general, perhaps. I wonder if you could say a few words about how you think the bill will lead to a better realisation of all children's rights for different equality groups. Juliet, please.
I think that it's such a strong tool for us to be able to advocate for the rights of children from across different groups. And it's such a strong tool for children and young people to know that their rights are protected in this way. We do see a way of actually enhancing the children's scheme to do that little bit more to ensure that it's really clear on the face of the bill that some children who've told us that they need extra help to make sure their rights are respected are actually really identified and set out on the face of this bill. We know from the consultation that we've had with children and young people that there are particular children who really struggle sometimes to access their rights. In the consultation events that you've been involved with, we've heard about children whose first language is not English, children who may be facing food poverty, children who can't go to school. So we would actually like to call on one further addition to ministers to include in the children's rights scheme a provision that requires them to report every year to set out steps taken to respect, protect and fulfil the rights of children with protected characteristics or in situations of vulnerability. This is something that we've spoken about far and wide across our membership, and we feel that it provides that hook that we need to really ensure that the bill meets its policy intention of realising the rights of all children and young people, and particularly those who are more likely to see their rights marginalised. I mean, I know that Carly and Una and Susie on the next panel will be able to provide real examples as to how this provision might make a difference to them in practice.
Thank you, Juliet. Carly, please.
Yes, so the bill has the opportunity of improving the experience of rights for all children, but as Juliet said, there are some particular groups that are worth considering more expressly within the face of the bill, and we would support Juliet's message around the addition to the children's rights scheme that she's outlined there. For care experienced children and young people, when the state makes the difficult decision to intervene in their life, they're not just disrupting the family construct of that child, But the child is then also entered into a world full of formal meetings and quasi-legal processes, and it can't be underestimated the challenge that they generally face in having their rights met and upheld, and even understanding what they are. I just want to quickly note on the experience of COVID-19 and the pandemic and how that has impacted care experienced children and young people specifically. Some case studies that might be helpful to kind of explain what this would mean day to day. Our advocacy workers across the country are supporting young people right now to challenge rights decisions that are concerning. Most prominently are issues around contact with family members. We have situations where children are being told that they are not allowed to have contact with mum, dad, brothers and sisters due to family members living in different tiers. And also being told that if they do go in contact with family, that they will have to isolate alone in their individual rooms and their care placements when they return for 7 days. These are challenging times, and we need to make sure that situations like this are clearly mandated for within the CRC incorporation bill, and that not only do children and young people understand their rights through this process, but also that the professionals and the adults around them understand how to utilise this bill so that we can all protect and uphold the rights of children, especially those whose rights are more challenging to understand day to day, especially right now.
Thank you, Carly. Josh, please.
Well, obviously, we would echo what Juliet and Carly just said. We place a really high importance on consulting with young people, as I'm sure you won't be surprised, but also consulting seldom-heard young people. We know often that certain young people will struggle more than other groups to access their rights, specifically vulnerable young people. Therefore, we'd like to see that provisions for this scheme extended beyond what's currently listed. For example, including independent advocacy within the scheme, which goes a long way in helping young people who may struggle to access their rights. We're very keen on ensuring that these young people are not left behind in the process, and would echo the calls of other partners in the bill to mention the needs of vulnerable groups and their protected characteristics within the scheme. It just really placing a high importance on recognising that this is not a one-size-fits-all policy, and we can't be leaving any vulnerable groups behind.
Thank you. Kevin.
Thank you. First of all, support the amendment proposed by Juliet. Also, thanks in particular to Carly for some of those tangible examples. As we said in our written response, the connection between children's rights, women's rights, the rights of disabled people, ethnic minorities, care experienced people, homeless young people, and many other groups, the issues that they face, really important point, has been exacerbated by COVID-19. Those existing inequalities have been highlighted, so we need to consider wider human rights protections, and therefore we're really positive about how we can focus attention on key groups within the children's scheme as outlined by Juliet. Cheers.
Thank you. Okay, if we can move to Alex Cole-Hamilton now, please, for his questions.
Thank you very much, Convener, and good morning to the panel. I should say for the record from the outset that I was a former employee of YouthLink Scotland, and I was also a director and convener of Together. So my question, firstly, is about the fact that the UNCRC is a living document, and it's adapted or interpreted in a range of ways, including general comments, optional protocols, and indeed the concluding observations of UN rapporteur visits. Do you think that Section 4 of the implementation of the UNCRC requirements should be expanded to take into account things like general comments and concluding obs, and any other opinions or international human rights treaties? And could there be any unintended consequences if the bill were amended in this way?
Thank you. Juliet, please.
Thank you, Alex. And yes, most definitely. We strongly believe that Section 4 needs to be amended to include decisions made under the third optional protocol of the UNCRC, as well as general comments and concluding observations, not just from the UN Committee on the Rights of the Child, but also from the other UN treaty bodies, in a way that aids the interpretation of the rights in the UNCRC. I think it's worth reflecting on the fact that last year we celebrated the 30th anniversary of the UN Convention on the Rights of the Child. And so this document is 30 years old. I don't know if the internet was invented 30 years ago, but the world changes, things change, and you need to see the UNCRC as a living instrument so that you can adapt and really view the rights in the text. And it's really strongly recognised that concluding observations and general comments and other interpretive sources are an authoritative way to see the UNCRC as a living instrument, to identify what rights look like in the kind of ever-changing world, and to understand the UNCRC in the modern context. We would never say that they're binding. They're not binding, and they're not seen being binding, but they provide extremely helpful and enlightening means of interpretation. And just some examples that we have: the UN Committee on the Rights of the Child currently drafting a general comment on children's rights in the digital environment. That's going to be absolutely key. We could have done with that right now as we're working in the pandemic with children and young people. It's going to be key to how we see children's rights in the digital environment. And there's general comment number 16, which looks at children's rights and the impact of the business sector. This helps to clarify some of the obligations on private bodies delivering public services, which is an issue that I'm sure we'll come on to discuss under Section 6. I think it's also important to include general comments from other treaty bodies, not just the UN Convention on the Rights of the Child. And this is because it's recognition of the interrelated, indivisible nature of human rights that Josh. It also helps to encourage alignment with other treaty bodies ahead of further incorporation, hopefully, of other human rights treaties, following on from the work of the First Minister's Task Force. So, for example, for the UN Convention on the Rights of Persons with Disabilities, there's a general comment on the right to inclusive education. Of course we should be looking at that. There's a general comment on women and girls with disabilities. Of course we should be looking at that. So Section 4 shouldn't just look at general comments from the UN Committee on the Rights of the Child, but should be looking at all treaty bodies. And just one last thing is that I would say general comments in this wider jurisprudence needs to be prominent throughout the bill. So it's not just including it in the interpretation clause, but I'd also strongly advocate that it should be reflected in the children's scheme as something that ministers should consider when they're making and revising the children's scheme. And that way we really bring together all of this expertise from the international community, and we're able to apply it in the Scottish context to make sure that this bill really is the gold standard. Thank you.
Thank you. Carly, please.
Yeah, Juliet has covered that perfectly. I think just some additional comments to add in there. We're very supportive of the inclusion of such things like general comments, including observations within Section 4. I think if there's ever a suggestion that the articles within the CRC are vague or difficult to interpret, then this is the way to get past that and to offer detail. And I think that's an incredibly important thing especially as we progress through the pandemic and as our understanding of the application of rights change and get more nuanced as time progresses. Juliet also mentions the need to consider such UN documents throughout other parts of the bill, including the design of the children's rights scheme, and I think that's an incredibly important point that we would support. I also just want to quickly note perhaps more in terms of the children's rights scheme and the drafting of any supporting guidance to this bill are the UN guidelines for the alternative care of children. If we want to better understand how we can support the needs and protect the rights of care experienced children, there are documents there are frameworks there that will help us to do that. So although we're talking here about general comments, concluding observations, perhaps reports of general days of discussion, I think it's worth noting the guidelines for alternative care of children as being a real important source of knowledge for us as we move forward.
Thank you. Josh, do you have anything you wish to add?
Yeah, so obviously we would echo what Juliet said. We fully support the idea of committee general comments, concluding observations and wider human rights treaties being included. It's an important level of accountability for decision makers to be held account for their actions on young people's issues. It's something that we actually spoke at length with our members and young people around this whole process, and obviously they emphasise really heavily that because they're experts, they know what they're talking about, and an objective stance is needed. Obviously paving the way for greater levels of insight into the processes around safeguarding our rights. And I thought this was really powerful. It's something that obviously we're really keen to protect.
Thank you. Kevin, please.
I think the point about the application being across the whole bill and being broadly interpreted when writing the children's scheme is really important. First flagged there by Juliet. So very quickly, UNCRC exists to inspire. We've heard that from numerous witnesses. It's a living instrument, and so the tools for interpretation should be maximised. Why? Because it's important to get back to the essence of what we're doing here today, and that is to protect and serve children and young people. And Norwegian judges, just as one example, do this all the time. So if they can do it, so can we. An explicit inclusion in the bill would keep up with the progressive and evolving approach that we're taking to rights right now in Scotland.
Thank you. Alex.
Thank you very much. Clear unanimity there across the panel. I'm very grateful for that. My second and final question is about commencement. The last piece of legislation the Scottish Parliament passed about children's rights was the Age of Criminal Responsibility Act back at the start of 2019. That didn't have a commencement date, and it still hasn't been commenced, and our age of criminal responsibility is still 8. This bill doesn't have a commencement date either. Are the panel concerned by that? And if that is to be remedied by amendment, how quickly would you like to see it implemented, and practically, is that possible?
Thank you, Alex. Juliet.
Thank you, Alex. I think this question is absolutely key. And we say that the bill must commence within 6 months of royal assent, so it must really commence by autumn 2020. And I think the example of minimum age of criminal responsibility really shows why putting a commencement date on a bill is essential. You really can't predict what might delay the commencement of a bill, whether it's a global pandemic or whether it's problems with the government IT system. The Commissioner last week, interestingly, he said that this bill is a bright ray of sunshine in what has been a very gloomy year. The Commissioner, he's not normally one for understatement, but I would say that this has been more than a gloomy year. This has been a year that's been absolutely dire for children and their families. We've seen thousands of children and their families plunge into poverty. We've seen 76,000 young people have the uncertainty of the exam fiasco, thinking that their future prospects were going to be dictated by the schools that they went to. We've had countless children unable to access their right to education during the pandemic. Children and young people from 2020 are going to be left traumatised by their experience during the pandemic. They're going to need real support to deal with this. We're yet to see what the potential long-term impact of lockdown on the educational attainment of children and young people is going to be. I woke up this morning to hear that we're facing the biggest economic decline in 300 years. Yesterday, we launched a report from the Children and Young People panel on Brexit, setting out their concerns about being able to live, work and travel in the EU post-Brexit. And so the combination of the pandemic and the impact of Brexit makes it more important than ever that we have these rights made binding in law. This is more than a gloomy year, and we've got many more than gloomy years to follow. So we have to make sure that this bill commences within 6 months. We have to make sure that children and young people's rights are at the forefront of COVID recovery. And we have to make sure that they have tangible rights in law that they can draw from, that we can use to really counter the disproportionate impact that 2020 has had on their rights and prospects so far. So yes, I completely agree, Alex. We must have commencement on the date of the bill. We must make sure that it's at the very most 6 months after the bill has received royal assent. And we must make sure that children and young people's rights are at the absolute centre of everything we do from this point onwards to counter what has been way more than a gloomy year.
Thank you, Juliet. Carly.
Yeah, we would just wholeheartedly agree with Julia. I think as soon as possible, within 6 months is crucial. And I think the reason that it's crucial is, again, because of the impact that the pandemic is having on children and young people, and most importantly, our most vulnerable children and young people. I think the impact that this is having on poverty worldwide should be noted here. I think the World Bank estimated something like COVID will push 100 million more people into extreme poverty worldwide in 2020 alone. And we know that the people who will feel that most for years to come are our current children and young people. So this bill in Scotland is really important and needs to be commenced soon in order to provide extra protection for these groups. Just to give you an example, there are decisions being made across the country right now, not through malice, not through any means intending to cause harm, but because of the difficulty in trying to interpret the pandemic and the associated guidance and guidelines that go along with it. One of our advocacy workers was supporting a care experienced young parent whose child was not in their care anymore, but there was a really robust package of supervised contact that was always intended to rebuild that relationship. The rules of the pandemic have intervened in that contact relationship. The young care experienced parent had their own mother being able to enter their home to provide support. They live alone, so that's an incredibly important thing for a vulnerable person. But because they had their parent entering their home, the decision was made to cancel contact because they weren't sure about how the inclusion of this person in their household might put the child at risk. That was a disagreement within the local authority, and I think the bill provides the opportunity to provide clarity to not just children and young people and what their rights are, but the local authorities themselves, which are trying to navigate and understand really complicated guidelines at the moment. So I think commencement needs to be incredibly soon because we are in a point in time where children's rights need to be protected in law.
Thank you. These examples are hugely helpful and illustrative for us. Josh, Scottish Youth Parliament's view on commencement, please.
Yes, well, MSYPs fully believe that this legislation should come into effect as soon as possible. We've consistently called for the UNCRC to be incorporated by 2021, and we would like to see the bill's commencing date realised by the end of the year. But it's important to stress that this would be a latest possible date in our view. As an organisation, we're very much aware of the strain the COVID-19 crisis has placed both on the Scottish Government and public authorities, and we do appreciate that this has changed the Scottish society since the initial 2019 consultation. However, the pandemic also highlights and exacerbates many existing children's rights issues, as well as creating new challenges. I note the SQA exam issue that's been mentioned by Juliet and being an example of that. MSYPs have raised a lot of rights concerns during this period, and obviously there's been quite a few to note. At our July sitting this year, for example, we proposed policy on the imprisonment of young offenders and ensuring that they still have the right to social distance and equal access to healthcare. This was passed by a massive 97%. Incorporation would ensure that imprisoned young offenders could access their right to be treated and respected with care, which is Article 37, and the right to the best possible healthcare, Article 24, throughout this pandemic, which is extremely important. Furthermore, over half of the respondents to our lockdown blowdown survey, which was done in partnership with Young Scot and YouthLink in April of 2020, had some concern over their ability to access rights as a young person within the COVID-19 context. And obviously we did see this with the SQA issue, with young people really concerned over their futures. The bill's commencement must be a priority, as it will provide the much needed protection that we need as children to navigate our way through the pandemic and the resulting recovery periods. We also anticipate many public authorities will also be prepared for the commencement of this bill. With these factors in mind, we do believe it is both reasonable and practical to call for a commencement date by the end of 2021, but we acknowledge that this should be the absolute latest. Thank you.
Thank you, Josh. Kevin, please.
Thanks, Ruth. I'll try and be as illustrative as I possibly can. Perhaps get the obvious, and it might sound generic, but important to say that we believe commencement should be done in as short and as effective a timescale as possible. We focused on this question with young people because we wanted to speak with confidence in sessions like today. So it isn't my answer, it isn't YouthLink Scotland's answer, it's me letting the committee know the majority view of our youth work sector. The committee heard a wee bit from Josh about lockdown lowdown survey there between ourselves, Young Scot and SYP. This has been an ongoing process, and we were going through literally thousands of written responses from young people on questions related to their mental health and their well-being, employability issues and on broader issues in their lives just last week. And you would need to have a heart of stone not to be affected by the sheer volume and level of intimacy in the answers around how disillusioning the pandemic's been for young people. And I was thinking this morning, it's also really important to note that those same young people who've made so many sacrifices are the ones who are at times most heavily stigmatised as a result of lockdown. And to echo some of the other comments that have been made, we can't afford to write a whole generation off as the COVID-19 generation. That is just not acceptable. So it's really important that we protect these young people from the disproportionate impacts of COVID-19. As such, we believe explicitly naming on the face of the bill a date that would ensure that we're respecting their rights, and beyond that, what a wonderful message that we could send, a message of real hope at this time. The short answer is, if it takes a date to focus people's minds, then 6 months would be acceptable.
Thank you. Thank you. And I'm going to move on to Mary Fee now, please. Mary.
Thank you, Convener, and good morning to the panel. The approach that the government has taken in this piece of legislation is to focus on a duty not to act incompatibly, rather than take a dual duties approach, which would include a due regard duty. And the reason they've given for this is because they've suggested that that could cause unnecessary duplication. Now, we've heard differing views as we've been taking evidence on this legislation. Some are supportive of the government approach, and some would rather they took that dual action and included a due regard duty. What's the panel's view on this?
Thank you, Mary. Juliet, if we could come to you first.
Certainly in the original draft Children's Rights Scotland bill that we gave to the Deputy First Minister on Universal Children's Day back in 2018, we did include a due regard duty and a not act incompatibly duty. And we thought that that was really important to ensure that we have this proactive and reactive approach to ensuring implementation of the UNCRC. We called it the carrot and stick approach, that we do as much as we can to make sure that there aren't any breaches of children's rights. And that's what the intention of the due regard duty was. But we also have the stick to make sure that if children and young people's rights are breached, they can do something about it and they have access to the courts and access to remedy. I think concentrating on the kind of policy ask of why we're asking that, it's about the due regard duty was about really front-loading children's rights in the decision-making of governments and in public bodies. And I think that that is where the children's scheme and the public body reporting duty really offer a way of achieving that same policy purpose, but without a due regard duty. And so that's why in our response, we really have recommended some additions to the children's scheme that really should be included. Such as data collection, human rights education, and steps to ensure access to justice for children and young people, including advocacy complaints and legal aid. And we feel that if these are actually on the face of the children's scheme, if these are things that ministers have to report on every single year, then it helps to put these proactive measures in place at a national government level to ensure that we do have that proactive approach to children's rights. The scheme is really strong already, but obviously we can always come up with ways that it can be strengthened. Obviously the children's scheme only applies to national government, and so we would welcome the consideration of a few more proactive measures to be included in the public body reporting duty as well. And we think that that would help to kind of fulfil what we were looking for from the due regard duty. So we really welcome the fact that listed public bodies have to report under Section 15 of this bill. We recognise that this will help to really promote rights-based policy making. What we would like to see is that this reporting duty isn't just retrospective, but it's a planning and reporting duty. Because if public bodies every 3 years don't just have to set out what they've done, but they have to set out full scrutiny by children and young people, by civil society, what they plan to do the next 3 years, then that would significantly strengthen the kind of proactive approach of this bill. And we would encourage public bodies to include in that what they're doing around child rights impact assessments, what they're doing to ensure child-friendly complaints mechanisms, what they're doing to ensure adequate data collection so they can evaluate the impact of their services. So I think with these additions to the public body reporting duty and to the children's scheme, we can really achieve that policy intention that we wanted through the due regard duty, perhaps in a kind of more proactive and more comprehensive way. Thank you.
Thank you. Carly, please.
Again, we would agree strongly with Julia, although we would be supportive of a due regard duty. We do think there are other methods that could take that intention of encouraging a kind of conscious and planned approach to day-to-day delivery of activities. And I think most importantly would be Juliet's suggestion around a more planning-focused addition to the public authority reporting duty. I think that could be an incredibly important addition. Juliet mentioned the creating expectation that the reporting will include steps around how to ensure there is provision of access to advocacy for all children, but especially for those groups that we've already spoken about today that might require additional means to be able to have their rights protected and fulfilled. There are areas we can learn from with regards to that. The corporate parenting duties within the Children and Young People Act have reporting requirements. We work closely with corporate parents. We support them through understanding what they can actually do to better the lives of care experienced people through their services. And we do see that the corporate parents who take a more proactive and planned approach to how they are reporting on what they're doing and how they're adapting their services have a much more positive experience of living those duties in reality. Those proactive steps also involve the engagement and participation of care experienced people directly, and I think that's something to consider here with the reporting duty. The participation of children and young people in the creation of both a planning and reporting document will be incredibly important. The corporate parenting work again is most successful in our view when corporate parents are engaging directly with care experienced people, but also with organisations such as ourselves and CELSIS in terms of being able to help navigate through what these duties could mean in practice. And I think that's a really important note to make here, particularly in relation to organisations like ourselves who provide independent advocacy and for years have seen what it means if you do not get rights protection right for this population of young people.
Thank you, Carly. Josh, please.
Well, I'm sure it's not surprising that young people want to see accountability on the part of public authorities, so we fully echo the calls made by Juliet, which was stated so perfectly on the reporting duties, as we hope they won't be too onerous. We also welcome the local authority and local government reporting duties too. Young people did want this concept of due regard, however, in line with responses from government, we would favour this idea of expanding reporting duties. However, obviously, we would favour whichever method would provide the most transparency and accountability for young people as possible, just to make sure that rights are protected. However, I'm a young person, unfortunately, I'm not an expert on technicalities, and as I'm sure you can appreciate, so we'd be more than happy to produce more evidence after the session, should you require.
Thank you, Josh. Kevin, please.
Thank you. The short answer is the bill could go further to ensure more proactive, positive measures to help public bodies with their decisions. and their priorities, and perhaps a due regard duty would be a useful addition. However, picking up on Juliette's points, making it a planning and reporting duty which must include what public bodies are doing, to include CREA data collection and human rights education, might be a more proactive and rights embracing approach to take.
Thank you. Mary Fee.
Thank you, Convener, and can I thank the panel for those very helpful responses. The next question I want to ask you is around the definition of a public authority. And in section 6 of the bill, the definition of a public authority is not exclusively defined, although its meaning has been considered in a human rights context in courts. And if I can give you one example before I ask for your broader views on definition. Section 6 says a public authority would include ministers, but not the Parliament. So can I ask the panel, do they think that the definition should be more clearly laid out in the bill? And if they do, what changes would they like to see in that?
Thank you, Mary. Juliette, please.
Thank you for this question, Mary. I think this is a key part of the bill that we really welcome the committee's scrutiny on. We do definitely think that the definition of public authority in section 6 does need an amendment to clarify the organisations that are included in the duty. And we really support the evidence that's already been provided by witnesses such as Dr. Katie Boyle and Andy Cyril from Just Right, and also the perspective of the Scottish Human Rights Commission. As highlighted in the previous evidence sessions, the definition of public authority used in the bill, it doesn't provide clarity. It leaves children and young people and those who provide services to them uncertain as to whether the UNCRC bill actually applies in different settings. And so it's really important to go back to what we're actually trying to achieve with this bill. This bill is about children, and it's about children's human rights. And it's about making sure that we protect children's human rights in all services that can be considered as being of a public nature. So it shouldn't actually matter who is providing the service. It matters that children have equal protection of their rights. And so, for example, a disabled child who relies on getting transport to school, if that transport is provided by a private provider, do we know whether that child actually has the protection of the UNCRC in that circumstance? Whereas if that transport was provided by the local authority, we would have clarity that it was. Once in school, if that school is delivered by a private provider, if it's a school that's delivered by the third sector, will the child have the same rights as somebody who's in a local authority school? We don't know. And we have these issues right across all sorts of areas of children and young people's lives. There are so many areas of children's lives where services are provided either by third sector providers or by private providers, and could be residential care, foster care, secure care. And there must be no inconsistency in how children experience their rights in each of these different settings. They don't know who delivers these services. All they care about is that their rights are respected, protected, and upheld. And I don't have the legal expertise to say how we tackle this, but I would really encourage the committee to consider the evidence provided by Just Right, Scottish Human Rights Commission, and by others to make sure that this bill does provide clarity on this issue.
Thank you, Juliette. Looking at the clock here and seeing we're halfway through, and I still have 3 colleagues to bring in and quite a lot of ground to cover. So just a reminder that if you don't have anything to add, that's absolutely okay. Not trying to stifle you here as I come to you, Carly, but just a reminder for panel members. Carly.
Sorry, I'll keep this short. We agree fully with Juliette. I think it's important to note the number of private providers and third sector organisations that provide services for care experienced children, and that is across the board. It can be their day-to-day care, residential providers, it can be mental health support, it can be education. I think if we don't include private providers and potentially third sector organisations within this space that provide similar duties, then we are going to miss a whole opportunity to protect children at their most vulnerable moments, and in relation to realising particularly their economic, social and cultural rights, which I think is something that we need to consider strongly within this bill.
Thank you, Carly. Josh, do you have anything you wish to add?
Just very briefly, I think it's important to mention that a lot of young people might not always make the distinction between what a public authority is and other care providers. So it's important that obviously any service on behalf of the Scottish Government or any public authority that delivers services for young people is included part of this bill. So this rights-based approach remains consistent. Thank you.
Thank you, that's helpful. Kevin, please.
Yeah, just to pick up on that point there, our sector's clear that youth workers and children and young people should be consulted in the preparation of public body reports, and that child-friendly versions accompany every part of the process. YouthLink Scotland were informed of concerns around this question, particularly around housing providers, childcare, private foster carers and public schools. So on that broad point, I would just reinforce broadly, despite not having legal training as such, not a solicitor, it's not beyond the wit of all of us here to ensure that children and young people across Scotland receive the same protection. There's a little point perhaps to be made in there in terms of that comprehensive approach, and it's that Scottish Courts and Tribunal Service seems like an obvious omission from the reporting duty at Section 15 and Section 16. And although it's said that that falls within a ministerial duty to report, I think, given the proximity and importance of SCTS as the duty bearers for young people, that it should be listed.
Thank you, that's very helpful. Okay, I'm going to move on to our next questioner. Gillian Martin, please.
Has nicely introduced my theme, because I do want to talk about existing courts and tribunals and their readiness and suitability for incorporating UNCRC. So existing courts, tribunals, rather than any new judicial body, will authorise judicial remedies proposed in the bill. And I'd like to ask the panel members if they think that they are accessible enough to children and young people, and if not, I'd like to know what changes you'd like to see here, either to the bill more generally or to those institutions, and also I want to know if you feel that they will be effective in practice. Will they focus on what a child, young person might want? Will they ensure changes in public authority concern for the benefit of other right holders in the future?
Thank you, Gillian. I wonder if we could go to Carly Elliott first for this question, please.
Yep, not caught off guard. Yeah, that's that's okay. I guess the enforcement of rights through the court is an incredibly important part of this this bill. Children and young people's right to legal recourse is incredibly important for creating accountability and also a last resort for challenging rights breaches that they have not managed to rectify through other means. That said, I would argue that the court process is inaccessible and intimidating for all people, never mind children and young people. And for that reason, I want to focus my answer on the other more proactive and alternative mechanisms that I think this bill should equally focus on, which we've mentioned in our written response as well. This is where the role of advocacy services are incredibly important. If the bill is able to focus more robustly on the provision of services like advocacy, then it means that children and young people could be supported to challenge rights abuses without having to step into the legal sphere. I don't think any of us want children to actually have to go to court, whether that's directly or through the sufficient interest test with other organisations. We want to keep them out of that space, and I think that's where the additions to the Children's Rights Scheme that Juliet mentioned earlier about including access to advocacy for all children, especially those that need it most, as well as the inclusion of child-friendly complaints mechanisms and procedures. Those will be the methods that will make sure that we don't have to, that children don't have to step into that legal space unless really urgent and necessary. In terms of child-friendly complaints processes, I think there are learnings, but I don't think we truly understand what a child-friendly process should look like. We've got lots of experience of advocacy workers supporting children and young people to lodge complaints with local authorities, with other organisations through their typical complaints procedures, and that we hear all the time that those experiences are unsatisfying. They lack communication, they lack feedback loop to children and young people about what's happening. They take long periods of time. And importantly, some of our advocacy workers reflect that actually it's that relationship-based advocacy support, which is the thing that often keeps children in the complaints process until the very end. Without that person helping you to navigate a complaints process like that, we wouldn't blame children and young people of opting out of their complaints process at early stages because of how convoluted and complicated they could become. So, in summary, I don't think the courts are necessarily accessible. I think, however, we do have incredible legal offers for children and young people, such as through clan child law and organisations like that take a really relationship-based, trauma-informed approach to how they support children and young people, but they are still entering an adult system, and I think that is our biggest challenge here and why this bill needs to focus more prominently on those additional measures such as access to independent advocacy.
Thank you. Juliet, please.
I think that Katie Boyle was very strong on the evidence that she gave around access to effective remedies, and I'd really endorse and support what she said. I do think that there's potential to strengthen access to an effective, the potential to strengthen the bill in this area by adding the right to an effective remedy. Because it's really important, as Julian says, that whatever remedies are available for the courts, that they're effective for the specific circumstances of children and young people, and they're also effective in addressing any of the systemic issues that might have resulted in the breach of that child's rights. So yeah, really, I could support the evidence given by Dr. Boyle and say that we'd really welcome the committee's consideration as to whether there should be an amendment, add the right to an effective remedy, or to allow courts to strike the balance of ensuring that just remedies are just effective and appropriate, because this would empower courts to be kind of more interventionist and help children to access a prompt and effective remedy. And I would also completely echo everything that Carly said, that really, we want the courts to be the very last resort. It's essential that children and young people do have access to the courts. It's essential that they can go to the courts and the courts that are accessible. But really, we want to see any breaches of children's rights tackled as close to the breach as possible. And that's why we're really calling for the children's scheme to be more specific on access to child-friendly complaints mechanisms, on access to advocacy, and also on setting out the steps that the Scottish Government are taking to ensure children and young people's access to legal aid, because that's absolutely key if children are able to take cases to the courts and if they are able to access a effective remedy. Thank you.
Thank you, Juliet. Josh, please.
So we're really pleased that the bill doesn't include a victim test. Obviously, it's really important that we draw a distinction between cases that are brought under a UNCRC breach, because they're being made on behalf of children and young people, a vulnerable group who might not always have the knowledge, the confidence and the ability and capacity to bring forward a case. It's a lot to ask a young person, especially one isolated and excluded from society, to do this. MSYPs have told us that they'd like to see a wider variety of individuals and bodies granted the ability to bring forward court proceedings. We therefore support the sufficient interest rule and believe that it helps ensure that vulnerable young people and children can be better represented in cases. MSYPs have told us that more clarity about who can bring about a case, the better. I think this point about it being intimidating is a really good one, and not to labour it too much, but I know even myself at 15, if I was to come into even an environment like this, I would have been a lot more nervous, and the capacity for that can't be overstated. We agree, obviously, with what Juliet and Carly have said, that more clarity should be provided on who exactly is enabled to bring forward a case. Having it written down in law would provide more clarity and more accessibility, importantly, to young people.
Thank you. Kevin, please.
Lots of really comprehensive answers there. Allows me to think maybe more broadly beyond the bill. Access to justice, we know from young people, remains a big issue. The bill is an opportunity to consider what we mean by access to justice, and I think for this bill to be a truly watershed moment, free access to advice, remedy and other forms of advocacy should be considered for all people, and I know this goes beyond the bill. However, if these sorts of discussions on children's rights can positively influence policy planning across government portfolios, then that can only be a good thing. In terms of access to justice, the prospect of Barnahus is coming down the road. Our colleagues, Children First, are doing a power of work there. So there is an opportunity for us to think in a less siloed way. So I would see the bill as part of a bigger discussion on how we make the youth justice system fit for purpose, and including how that can be more inquisitorial, which we know from research gets better results, and that would mean the system would be in keeping with what we want to achieve from incorporation. Someone in one of the last committees said the system was designed by adults for adults. That certainly chimes with us. We have numerous examples of support at the point of disclosure within the youth work sector, and I would commend one model, and that is 6V Young Victims of Crime Service based in Edinburgh. I won't go into too much detail, but I will pass on information after the committee session. And what I would recommend is that the National Task Force on Human Rights Leadership looks into this specific question in more detail so that we can positively evolve the whole system for children over time.
Thank you, Kevin. That's helpful. We would appreciate that that further detail if you're able to give us it after committee. Gillian.
I have one more question, but I want to come back and just ask Kevin something. You mentioned Barnahus, and you did say earlier on that, like, Norway have incorporated UNCRC really effectively. Do you think that is one of the reasons for that is because they have the Barnahus system over there already?
Yeah, absolutely, and research tells us that that is the case, and it also gets better outcomes no matter where you are within the justice system. You know, if you're a perpetrator on in need of rehabilitation, or if we're looking at restorative justice, it's part of a swathe of progressive measures. So working with a system is certainly easier than taking a bill forward within a system. I think we also have to face the realities of where we are and get this bill through, but certainly not neglect any good models of practice that we can take from our international partners.
Thanks, that's really helpful. And sorry, Convener, I was just saying that Carly did mention other public bodies as well, and I was wondering whether the other panellists would like to reflect on whether public bodies already have sufficient child-friendly complaints processes at public authorities. That's something that Carly mentioned, and I'd like to know what the other panellists think about that.
Okay, Juliet, please.
Quite simply, no, not yet. There's a lot of work that needs to be done in this area. We've done our best actually ahead of this session. I wanted to be able to highlight really good practice in terms of child-friendly complaints mechanisms. And I have to say it's actually really quite patchy, and we haven't in Scotland been able to find kind of a really good model of a child-friendly complaints process to be able to put towards you. Interestingly, the Welsh Parliament did an inquiry, or published an inquiry this summer into the implementation of the Welsh measure. And And again, in that inquiry report, they've actually called for better child-friendly complaints processes. So I think that this is something, it's a challenge that we're all facing, and I think we need to look more widely at the international community to find some really good examples that we can highlight, that we can publicise, and really encourage public bodies to pick up on. Because it's in public bodies' interests to have really good child-friendly complaints mechanisms. Because if children and young people can raise concerns about their rights really early on in the process, it stops the problem from escalating. It stops the breach from becoming more serious. So I'm certain that we'll be able to work really closely with public bodies to find and learn from each other how we can best support child-friendly complaints and come up with a model that really works to support the intention of this bill.
Thank you, Juliet. Josh, Gillian's question there on child-friendly complaints.
Yes, well, just quickly, I realised that I actually responded with the wrong note. So just as a very quick sum up, we don't have an official stance on this specific area. However, we do know from a recent focus group we ran with MSYPs to inform the Family Law Review that young people do want these changes to be made the way courts proceed to ensure that our youth friendliness is so important to make sure, obviously, as Juliet said, that young people feel able to and we're realising rights more fully. And we really believe that there should be adequate support in cases and access to counselling during proceedings. I would fully echo what Juliet had said on this. I think, not to labour, but it is so important that young people are able to access these rights fully so that we can move forward to be a rights respecting society in Scotland. I hope that answers your question.
Thank you. Kevin, Gillian's question there on child-friendly complaints processes. Any
well, yes. A challenge. I was actually smiling there because I'm just in admiration of Josh's honesty. It happens to everybody. On the question, it's important to start from what young people tell us. They want us to let them know who they can safely complain to. Youth workers are often the first port of call for young people. So we know that whatever we do, it needs to be simplified, in plain language, easy to understand, non-confrontational, and at the pace of approach dictated to by the young person.
Thank you. Gillian, are you content if I move on?
Yes. Thank you everyone.
Alison Harris, please.
Thank you, Convener. I would like to discuss court proceedings. Section 10 specifically empowers the Children's Commissioner to raise court proceedings in respect of the duty on public authorities. More generally, Section 7 of the Bill says an individual or organisation can raise court proceedings in respect of this duty. In practice, however, for judicial review proceedings, litigants will also be required to demonstrate sufficient interest. So could I ask, are you happy with this overall approach, including how the government's policy intention is given effect to the wording of sections 10 and 7 of the bill?
Thank you, Alison. Juliet, please.
Firstly, with regards to section 10, we really welcome the fact that the Commissioner is included on the face of the bill and able to raise proceedings on behalf of children and young people. This is an essential way of ensuring children's access to justice and making sure that some of the more embedded systemic issues around implementation of the UNCRC can be addressed, and some of the more serious issues affecting children and young people's rights can be addressed. So we really strongly endorse and welcome the provisions that are included in section 10. In relation to section 7, then in our response to the committee, then we did say that we would welcome kind of clarity that the provisions of as drafted do achieve the policy intention. Overall, we welcome the approach that's been taken. We welcome the removal of the victim test. We understand that courts interpret sufficient interest very broadly, and we see this, particularly together as a membership organisation. It's a significant development for organisations to be able to take cases on behalf of children and young people, because this will allow us to support children who are in the most vulnerable situations, who might not be able to take a case themselves. I think you had really strong evidence from Andy Cyril from Just Right in the first session about the importance of this provision to be able to raise cases on behalf of asylum seekers, asylum-seeking children who may not be able to navigate the complex legal systems and may be facing so much trauma that they need to get involved in legal proceedings. It would mean that proceedings. I think.
Sorry, Julia, your sound dropped a little bit. I think we are hearing what you're saying. So if you just
dodgy Wi-Fi, sorry. But yeah, just like we do, we welcome Section 10, we welcome Section 7 and the policy intention of Section 7, but we would also welcome clarity that the provisions in Section 7 actually achieve the policy intention.
Thank you.
Carly, please.
We are supportive of both sections identified in this question. I think we are especially supportive of the exclusion of the victim test. I think that's an incredibly important thing. It strengthens the bill to have the definition of sufficient interest test included. The only thing that I want to add to this discussion here is organisations like ourselves would be primed to be an organisation that might take cases to court through the sufficient interest test. We see rights issues, systemic rights issues all across the country. We have advocacy workers in almost every local authority in Scotland, and we have presence through participation in every local authority. So organisations like that work with a kind of national remit especially will be able to see these issues across the board, and I think that's an incredibly important thing to know and to have the power to do. The only thing that I'll say that I think we need to think about is sufficient training and education for organisations like ourselves as to what it might mean to take proceedings to court or raise proceedings, whether that's through the Children's Commissioner or otherwise. And I wonder if the duties in the bill provided to the Children's Commissioner could also take account of the fact that we will need sufficient training to understand what it means to take cases to court on behalf of both individual and collective groups of children and young people. That would be the only addition to this question.
Josh, I know you shared some reflections on this in a previous answer, but if you want to tell us again, that's okay.
Yeah, well, obviously I would refer you back to that, and it's so important that in this sufficient interest test that it would be good to get clarity as where this applies to young people and who it applies to, and so it's clear on this. But also, I think it's worth stressing that we're delighted about this inclusion about the Children and Young Persons Commissioner. It's a really positive step. Once again, when consulting with young people, they told us how they felt it was essential that bodies such as this one had powers, as many children and young people, as you know, struggle to have the knowledge and confidence to bring about their own complaints. Certain heard young people, whether this is care experienced young people or disabled young people or more, are more likely to have less confidence and knowledge to take action against rights breaches. And through this provision, we can take meaningful steps in safeguarding our rights and providing some equity on this.
Thank you, Josh. Kevin, please.
Lots of great stuff. We too think it's really positive that the Children's Commissioner can take cases on behalf of young people. This will be hugely important as part of the implementation phase and also more broadly in recognition of children's rights in Scotland. Worth getting on public record that there has been some discussion with youth work leaders on this point. There are some, a minority, but some enough to mention, that would like to see explicit mention of youth workers on an appropriate frame of wording to mean a particular youth group could take a case on a young person's behalf. Our sector's not alone there. However, you have been listening to many of the arguments on how sufficient interest is currently applied, and we're persuaded that it is interpreted widely, and the victim test not being included does represent a welcome widening of access. So the short answer on the point of Section 10 is that we'll support the approach that allows the youth work sector be utilised to its fullest potential in that space. Section 7, the short answer to the slightly longer answer, but it won't be too long, echo what Juliet said, that clarity is required to achieve the policy intention. It's crucial that evolving capacity and maturity of young people are taken into account as they progress through the ages. I think the comments on balance of power merit really strong consideration, especially when there are vast differences in a young person's capacity to access the law. And this is often due to issues that are out with control, just some of them, information, finance, advocacy, or just being in a situationally disadvantaged position. So, agree, Section 10, spot on. Section 7, wee bit more clarity required.
Thank you. Alison.
Yes, thank you. Now I would like to ask about time limits for bringing court proceedings. The committee has received written submissions offering mixed views on whether it's correct to exclude the period when a young person is under 18 when calculating the time limits for raising court proceedings under Section 7 of the Bill. Would you like to comment on this issue or the approach to time limits more generally under Section 7 of this Bill?
Juliet, if I can bring you in, please.
Yeah, certainly. We strongly support the policy intention behind the provisions around time limits in Section 7, because it supports the evolving capacities and maturity of children and young people as they get older. It recognises that they really ought to have the right to have a say on acts that were done to them when they were too young to do anything about it themselves, or when they weren't aware of whatever happened was a breach of their rights. Really importantly, it addresses, as Kevin just said, the issue of balance of power. Those children who are most likely to experience breaches of their rights are those children who are perhaps in secure care, perhaps in their care experienced children and young people. The idea of being 10 years old and taking a case against the corporate parent or against those who are supposed to be providing care to you, it's terrifying. And so there's no way that we can really expect children and young people to always be able to take cases at the time that the breach occurs. It's really important that we give them the option or possibility to raise cases right up until after they reach the age of 18. And I think, Who Cares Scotland, Carly always has really strong examples of the kind of fear that children and young people have of even raising complaints against corporate parents. And so the idea that a child would actually take legal action against a corporate parent is just unthinkable to some children and young people. So yeah, we absolutely welcome the policy intention of Section 7. We think it's essential in terms of children's access to their rights and ability to be able to bring claims against breaches of their rights. We do just want to check that the bill as drafted at the moment does meet its policy intention.
Thank you, Juliet. Carly.
Yeah, we are wholeheartedly supportive of the time limit provision and the ability to start the clock at age 18. I think I would just be echoing everything that has already been said, and the discussion around the power imbalance that children and young people face is an incredibly important one here. No more so than for care experienced children who, like I said, as the state intervenes, they are thrust into a world that is full of formal processes and legal interventions, and we can't, that's worth stating again, I think, within this discussion. Children may not realise that their rights are being breached, and I think the removal of the typical time limit is a helpful thing to acknowledge that. I think also Juliet mentioned the situations that we hear all the time from young people about how they feel disempowered to raise challenges against the people who are tasked with their care, their corporate parents and whoever else. I just want to read a quote to you. We in shaping up our response to this bill and ongoingly engaged with our Care Experience membership through a variety of means. I've included some of that within our written response to you already, and we'll be shaping up and sharing with you a broader report which reflects on this in the next couple of weeks. But I think this quote answers this really well. The environment wasn't child friendly. I felt that I couldn't talk about if my human rights weren't being met. I couldn't say anything about my home with that person I live with sitting right next to me. Can I really express what my rights are without causing offence and damaging my childhood home any further than it already is? I think that's incredibly powerful, and I think it makes the point about how we can't expect children at a young age to immediately raise issues and understand what that would mean. Thank you.
Thanks, Carly. That is indeed a powerful example there, speaks to that balance of power that we were talking about, or imbalance of power, I should say. Josh, we can come to you.
Thank you. We don't have an official policy stance on this, but I do think this is undoubtedly a really positive step, given that young people have told us that they want to be able to access their rights as easily as possible, and no doubt that this will help facilitate that. With this in mind, we do welcome these provisions alongside the provision that allows that cases brought forward more than a year past were considered equitable. This is because we appreciate that both younger and more marginalised children may not yet have the capacity or desire to bring forward a case, but they might do so as they age. I know at 12 myself, I definitely would not have had the confidence to do that. So I think this is extremely positive, especially in cases where young people are reliant on toxic situations and feel threatened about challenging it. I thought that Carly brought an excellent point up there just to maybe echo that. And we do agree with Together's concerns here about this happening in practice and how we can work on making sure it works. Thank you.
Thanks, Josh. And Kevin, time limits for bringing court proceedings.
Yeah, I mean, I think I possibly answered that, and people have gone on to give very, very good examples. So I don't have much more to say for the purposes of the record. However, there wasn't anything that I disagreed with there. That was absolutely brilliant. Maybe just to say that during the co-production of the new National Youth Work Strategy, there was engagement with thousands of young people, both directly and through written surveys, and accessibility came out as one of the top themes. So we'll have a job to do in the next year, seeing how a lot of the questions and how a rights-based approach can fit with the National Youth Work Strategy.
Thank you. That's helpful. Alexander Stewart, I could come to you now, please.
Thank you, Convener, and good morning, panel. Can I talk about the review for the provision of Scottish ministers preparing the Children's Rights Scheme? Now, there has been some suggestions that the language within the bill could be stronger or could have more impact. So can I ask the panel's view on that? What do they think that the contents of the scheme should be? Because there have been examples mentioned about youth work that maybe hasn't featured and should feature within that rights scheme.
Okay, Alexander mentioned youth work there, so I'll come to Kevin Kane first on that question, please.
Yeah. No, but there was a number of other sectors and people and groups who perform that key role of connecting young people and issues in their community and their skills. So what I would firstly say is that the children's scheme is really important. It does link to the actions we need to take to realise the ambition and the bill, and it will help keep ministers that accountability there. The stronger and the more explicit the scheme, the better. If that's my partial answer on that one. In terms of the contents and the wording, the may that's in there at the minute should be replaced with must, and we could work alongside government on the clear processes for children and young people, particularly in relation to access to legal assistance and how the youth work sector can help. We understand that process will require reviews of legal aid and resourcing to ensure that all children have access to confidential and independent legal assistance. Won't come as a surprise that we'll always advocate for investment in the youth work sector, and there is research there that you get a social return for your spend in the sector, and as a sector whose national outcomes are enshrined by UNCRC and as a key deliverer of incorporation, then that's quite an easy connection for us to make. In terms of advocacy, we did do some workshops on the future of youth work in Scotland, and it came up time and time again that they need support and advocacy to enable them to access their rights. Carla made some really good points about that. They also spoke about the importance of knowing what mechanisms are available to them. It's also important, as we mentioned before, to recognise the broad swathe of rights and those who we might consider actually explicitly mentioning within the scheme. And children's complaints mechanisms could also be discussed in the round here as well. I hope that answers. Does that answer your question?
He's nodding, Kevin. Yep, that's helpful. Thank you. Juliet, you've spoken a bit about strengthening the scheme. I wonder if we could hear a bit more from you on that, please.
Yeah, certainly. I mean, I agree with Kevin. I think it's the scheme itself is very strong, and we were delighted to see within the scheme specific requirements on children's participation, on raising awareness of children's rights, on budgeting, and on CREA. And these requirements are only kind of associated with a may duty at the moment. So ministers may set out what they're doing, and our members are very clear that ministers must set out what they're doing around these essential areas of implementation of children's rights. Interestingly, then, there's a children's rights scheme in Wales, and I mentioned before the parliamentary inquiry into the implementation of the scheme in Wales. And this inquiry found real gaps in terms of practice, in terms of certain areas of children's participation and child rights budgeting. And you could really argue that it was actually a failure to specify these elements as essential parts of the scheme that have resulted in some of these areas not being properly embedded in Wales. So taking that learning, we do also think that the scheme should explicitly require ministers to set out what they're doing every year in terms of children's access to justice. So we've touched on advocacy, complaints and access to legal aid, as well as data collection. We need to know what ministers are doing to collect data to assess the impact of the measures in the scheme, the impact on children's realisations of rights, because that's the only way that we can make sure that we direct resources in a way that counters some of the issues that we're facing in implementation. And we'd also like to see human rights education on the face of the scheme, as well as we mentioned at the beginning, the steps taken to secure the rights of children with protected characteristics and those in vulnerable situations.
Thank you, Juliet.
Just going to echo exactly what you've heard already. I think the language in this section needs to be strengthened to create more compulsion by replacing may with must, as my colleagues have already shared. I think getting the detail right in this area is the thing that will embed rights most prevalent in a more prevalent way for children and young people day to day, and is the thing that will prevent them from having to go to court if we get this bit right. Like Juliet and Kevin have both said, I think the scheme could be strengthened by the addition of considering child-friendly complaints mechanisms, education on human rights. I just want to note Tia Muir, one of our Care Experience members that met with both the convener and Gillian Martin through the engagement sessions with young people. She noted quite strongly the importance of a public education campaign that not only targets children and young people, but also the professionals in and around their lives. The addition of access to advocacy for all children, but very explicitly for those groups that need it most that have formal interventions in their life. And just lastly, that very specific reference to groups that do need extra consideration, such as care experienced children, will be important. And just to note that cannot alone be reference to protected characteristics, because that does not cover care experienced children. So a form of words which we collectively can suggest to the committee would include protected characteristics and children in situations of vulnerability, to make sure that we are accounting for all children who need that additional access.
Thank you, Carly. Josh, the Children's Rights Scheme.
Just to keep it brief, MSYP felt that this was a really important and positive aspect of the bill, that provisions for a children's rights scheme was included. They said that the scheme will get children engaged in rights and will bring about accountability. So we're really pleased to see its inclusion. It could obviously be strength, echoing this May becoming a must. SYP is work and is founded on Article 12 of the UNCRC, young people's voices being heard, and we do see some good examples of this, obviously referring to children's and young people's meeting with the Scottish Cabinet where we can raise issues directly to government. So obviously, like in line with this, we would like to see this trickle down, this rights-based approach to participation in this legislation. We also note that we would echo the calls of Juliet on education and human rights being at the face of this legislation. Thank you.
Thank you, Josh. Alexander, I'm going to move to Fulton now, who's got a question about children's rights and wellbeing impact assessments. I know you have questions around resourcing, but I will come back to you. But if I could go to Fulton first, please.
Thanks, convener, and good morning, panel. And thanks for all your answers so far. It's been very interesting. As the convener says, I want to ask about the children's rights and wellbeing impact assessments. So can I suppose there's two parts to my question. Can I ask for your overall views on these assessments, and then more specifically what your views are on the legal duty in Scottish ministers to prepare these assessments for legislation and for decisions of a strategic nature, and I suppose to what extent do you think ministers should have that discretion?
Thank you.
And happy just to go over what the convener said at the start. Thank you.
Yeah, please.
So we strongly welcome the provisions in section 14 that places the duty on ministers to conduct child rights impact assessments on decisions of a strategic nature. We do think there's a bit too much discretion included within that duty because it talks about kind of as they consider appropriate, and we would quite like to see that bit of the bill removed. I think that this is really timely because research shows that there is still inconsistent use of child rights impact assessments in Scotland. Sometimes they're undertaken too late in the policy making process. They're not yet fully embedded across all areas of government, so it's important that they take place not just within children's services, but on all areas of government that impact on children and young people. So to include, say, transport and the environment and wider areas of government work that impact on children and young people. The Welsh inquiry that I mentioned before concludes that the lack of a statutory requirement for career in Wales is a weakness. And so I think having this in the incorporation bill is a real strength. So overall, yeah, we welcome it, but we would like to remove that layer of ministerial discretion to really make sure that it's very clear that all decisions of a strategic nature need to have a child rights impact assessment done on them.
Thank you, Juliet. And Carly, please.
Yeah, we would agree that there possibly is a little bit too much in the way of discretion within the bill currently, and we would recommend a strengthening and a more propulsion in relation to this issue. In a more kind of broad reflection on the use of child rights wellbeing impact assessments, when used well, they can lead to really effective and rights-based decision-making and planning, and I think that is incredibly important to the overall policy intention of this bill, if done right and if done well. The challenge is that sometimes they are not, and they become a tokenistic measure. I think you've heard quite strongly from people giving evidence already on that issue. So my only addition to this conversation would be again around we need to train people effectively on the purpose of using rights impact assessments, how to do them meaningfully, and what actual benefit people can actually get from undertaking such an assessment. Because this isn't just about benefiting children and young people, although paramountly it is. It's also about helping people to understand how to do their jobs in a way that takes a rights-based approach, and that is fundamental to the whole purpose of this bill.
Thank you, Carly. Josh, please.
So, thank you. We welcome the legal duty of ministers to prepare children's rights and wellbeing impact assessments on any new legislation introduced to Parliament. As the MSYP said, this will bring about accountability. This is a key theme of the evidence that we've been submitting to you today. We do think, however, that a wider clear process could be strengthened by limiting this discretion of ministers to determine when this should be used. Young people wanted full and direct incorporation as they believe the rights should not be tampered with by decision makers, and we believe that allowing ministers to decide when it's appropriate could allow for these policies to slip past the review process. We also hold a concern around the discretion given to publish these in such a manner as the ministers consider appropriate. NSYPs have specifically told us that these should be made accessible to children and young people to enhance accountability and equality. We believe this is a straightforward but essential element to making children's rights a reality in Scotland. Therefore, we do think it should be made a requirement to publish these also in a child-friendly format. If it's youth-friendly, it's everyone-friendly.
Thank you. Very good point. Kevin, please.
Well, specifically, we welcome the Section 14 provisions. However, Juliet mentioned the section on as they consider appropriate. That needs to go. That's not good enough. More broadly, we know that impact assessments are vital to ensure that decisions are made effectively. I'm aware that the evidence across Europe is varied. However, what does come through strongly is that the higher the quality and consistency and obligatory nature of the approach, then the greater chance of success. And perhaps it goes without saying, but I'll say it anyway, training and support needs to be in place around this issue as well. And our sector has masses of experience in this area, and again, happy to pass on examples of where we have taken a proactive approach in terms of training in the context of rights.
Thank you, Kevin. Fulton, do you wish to come back in on that?
Yeah, it's actually on a new question. I want to thank the panel for the answers, and I think that covered everything. But I wanted to move on to part 4 of the bill. And I know that each of you have actually, put something in around this in your written submissions, but to give you the opportunity to say anything else here on the record, as you'll know, part 4 of the bill sets out significant powers in respect of incompatible legislation. And if you want to take this opportunity to have any comment you want to make in part 4, and as a committee we're particularly interested in your views on the court's powers relating to incompatible legislation and the reporting duty as set out in section 23. I'm aware of time, and I know that you've each commented this in your written submissions, but as I say, to give you another opportunity to have it on the record.
Thank you, Fulton. Juliet, please.
In a nutshell, we really welcome what's included in Part 4. We welcome the fact that the courts have been given strike-down powers on incompatible legislation that's made prior to commencement to this bill. We recognise the limitations on the powers of the Scottish Parliament, and that we can't include strike-down powers on legislation going forward. So we welcome the steps taken to put in the requirement for I can never say this, declarations of incompatibility and incompatibility declarators. So we really welcome that. The one bit that we would add to that is that there is a provision that requires Scottish ministers to set out what they're doing to action incompatibility declarators. And we think that this duty should include a requirement to publish child-friendly versions of what they're doing to action incompatibility declarators, because it's so essential that if a case has got as far as court, that ministers really speak to children and young people about the action that they're going to be taking to remedy an incompatibility declarator. Thank you.
Thank you. Well done for saying that 3 times as we tend to avoid it. I can say it. Carly, can we come to you, please?
Yep, this will be a short answer. We are fully in support of this part of the bill. I would agree with Juliet that there needs to be something around the feedback loop to children and young people here. The provision within part 4 of the bill was something that spoke really well to the group of young people that we again supported to meet with, some of the committee members. They were particularly interested in what this would mean, and they almost felt as though it wasn't just the legislation itself, but it was looking forward and future-proofing protection of children's rights in Scotland. And the fact that they were particularly interested in this very complicated thing that uses the words incompatibility declarator and strike down powers, I think is a notable thing to consider, and therefore the inclusion of something which recognises the need to feed back to children and young people in accessible ways will be really important for the committee to consider going forward.
Thank you, Carly. Josh.
Yeah, so we'd just like to echo what Juliet and Carly have put so excellently about. We also welcome the strike down powers and the provision to work within the Scottish Parliament's competence. Again, just one final time to stress this accountability and accessibility point. Any provision that can make this better and more accessible for young people, we would totally welcome.
Thank you, Josh. And Kevin, please.
No, Josh put that wonderfully. He summed up that really, really well. I've got nothing further to add on that point. Thank you.
Thank you. Dalton, are you content for me to move on? Yep, he's nodding. Okay, Alexander Stewart, please.
Thank you. And final question. I want to ask the panel convener about the resource implications potentially for this bill, because everything comes with a cost. And we've already heard this morning about the possibility of training and support that may require to be added. So that could have a resource implication on organisations, on public authorities, or on the third sector. So it would be good to get the panel's view if they do see that there's maybe a potential burden, or there is going to have to be resources found to try and manage to ensure that all of this will be captured by these organisations.
Thank you, Alexander. Juliet.
Thank you for that question. I'm really positive about this. Taking a rights-based approach leads to better and more cost-effective decision-making in the long run. And so it is important that there's proper resourcing to raise awareness and understanding of the UNCRC, but we're building on a really long history here. I said at the beginning, we celebrated the 30th anniversary of the UNCRC last year. We've had GIRFEC in place, getting it right for every child in Scotland since 2006. The 2014 Act actually already obliges Scottish ministers to raise awareness and understanding of the UNCRC. So that is actually already there. We already have that commitment. A general comment from the UN Committee on the Rights of the Child really reminds us that investing in children has to be seen as a long-term investment. And investing in families is an important way of securing children's rights. And so I think the provision in the Children's Rights Scheme about child rights budgeting will help government to prioritise existing funding in a way and ensure that resources are directed in a way that the rights of children and young people are upheld and that we comply with the UNCRC. And I think together, the Scottish Alliance for Children's Rights is a really good example that a small amount of money, we're a tiny team, can go a really long way in raising awareness and understanding of children's rights. So it doesn't have to be expensive, it just has to be effective.
Thank you, Juliet. Carly.
Yeah, there does need to be investment in the way of training and education, as was already, but just to echo something that Juliet said, a lot of this work is already happening very robustly across the country. There are already really effective mechanisms for learning about your rights, for being able to work out how to challenge and have rights upheld. So it's about strengthening mostly what already exists. We have organisations like the Children's Commissioner, who is very in a great position to be able to offer enhanced training and access of information to people, and I think that would be a really important thing to consider. The only thing that I think is worth considering further is access to advocacy. It is crucial to invest in more access to independent advocacy for all children, but very specifically the groups that we've mentioned already today. The provision of advocacy currently is poor. It doesn't reach the number of children and young people that need it, but it is absolutely essential if we want to invest upstream and prevent children from going to court. So I think that's something that needs to be considered. And just to note something about the lifelong impact of this, if we invest in advocacy services, particularly for groups like care experienced children and young people, cannot underestimate the impact, the positive impact that will have lifelong on those individuals all the way through to adulthood. And so while there will be investment implications, I think that is I think it's essential, and I think it will be saving overall if we invest early in and measures like independent advocacy.
Thank you. Josh.
So I don't have too much to add on this. Obviously, this isn't a new concept to Scotland. With the 2014 Act, we know that there are requirements already in place. This is a next step on the journey, not a new one. I do want to echo and perhaps add to the points made about this being an investment for the future. This rights-based approach is so important. Obviously, we're putting provisions in place to protect young people in law and in court, but we want to be preventing this, getting to this stage as much as possible. By taking a rights-based approach, we're ensuring young people's futures are more secure, and we're in effect making sure that there's going to be less of a burden on the state by doing that, because young people will be empowered as part of this.
Thank you, Josh. And Kevin, please.
The answer is a yes and a no, depending on how we approach it. And other panellists made that point very well. However, like any ambitious bill, there does need to be an honest look at the financial memorandum and the implications on the bill. I found looking at the previous testimony really helpful to get a feel for genuine worries. Research shows that UNCRC incorporation never increased in litigation, which is a really interesting fact. It showed that incorporation is as much about a culture shift as it is creating a space for those few cases where litigation is merited. The approach works. It's also, from our point of view, we've engaged a lot of youth workers who operate in the heart of public bodies. And although we get the instinctive worry on resources, they're much more excited by the immediacy of incorporation than anything else. And to use our Scandinavian neighbours again, as Sweden approached incorporation, the government designed a national programme to support local and regional communities and national agencies to support the implementation of that law. This is a space we believe the youth work sector can be harnessed. We have multiple examples of working in schools and communities to deliver large-scale training and material on rights-based issues, but it's not just us, it's all those other agencies and sectors, children's groups, social work. The evidence is there that when incorporation comes, there will be a mass mobilisation of people and groups at its back, ready and willing to ensure that it's a success. But the question is actually one of how do we use existing infrastructures to ensure that it is?
Thank you, Kevin. I am very conscious of time. We've kept witnesses far over what we said you were going to be here for, so I'm going to draw this session to a close. We have had really good evidence, really helpful, good examples. If there's anything that you didn't get the opportunity to say in either your written evidence or our oral evidence session this morning, then please do feel free to correspond with the committee. So Juliet, Carly, Josh and Kevin, thank you so much for taking part this morning. Please wait for broadcasting to switch off your video and microphone. You're then free to leave the meeting, and you can of course continue to watch on Parliament TV if you so wish. We'll now suspend briefly while broadcasting set up panel 2. Thank you very much. welcome back and good morning to witnesses on our second panel. Una Brown, Policy and Implementation Officer, Scottish Commission for People with Learning Disabilities. Beth Cadger, National Co-Coordinator, Article 12 in Scotland. Susie Fitton, Policy Officer, Inclusion Scotland. And Afrika Priestley, Lead Anti-Racist and Pro-Black Ambassador, Intercultural Youth Scotland. Thank you all for joining us this morning, and thank you for your patience as we concluded our first panel there. We need to conclude this session by no later than 11:45, so a plea for succinct questions from members and answers from panel members, and just a reminder to give broadcasting a few seconds to operate your microphones before beginning to ask a question or providing an answer. So if I may start, there is strong support for direct incorporation of the UNCRC into Scots law, and as committee heard, this bill is unique in international terms because it includes active and reactive measures. Can I ask panel members for their views on the approach that the Scottish Government is taking, and particularly interested to hear the reflections on the potential benefits or disadvantages of this approach. And I should have said we'll work to the order that witnesses appear on the agenda. So if I could come to Una Brown first, please.
Hi there, and thank you for having SCLD along today to give evidence. I think similarly to the participants on the last panel, SCLD is very supportive of full and direct incorporation insofar as it is within the power of the Scottish Parliament, and we welcome both the proactive and reactive measures. I think what was really critical and what came across in the last panel was what Josh said about full and direct incorporation not diluting rights, and also the cultural change which was raised by Juliet. I think for SCLD in particular, the move towards Scotland becoming a rights respecting nation and the work that's been done on the UNCRC bill is critical because it's created a discussion around the potential to incorporate the UNCRPD as we move forward. And I think for us as well, what's been particularly heartening about this process is that we have had opportunities for children and young people with learning disabilities to be heard by committee members at previous sessions and to have a seat round the table and be part of this process. While we're very supportive of the bill, we would want to highlight that we have concerns that children and young people with learning disabilities whose human rights may be viewed as more challenging or resource intensive to fulfil might at times be overlooked. I think in line with other comments earlier, we would welcome the bill being strengthened for children and young people with learning disabilities through several small amendments, which we believe will make a big positive impact on the lives of children and young people with learning disabilities. I won't go into detail on these now, but just as headings, it's to make sure that children and young people with learning disabilities are visible in the bill, by future-proofing the bill for wider human rights treaties incorporation, and by ensuring a reporting process that includes data disaggregation, as well as ensuring accountability for public authorities. Thank you.
Thank you, Una. Beth, if I could come to you on that question around the Scottish Government's approach, please.
Morning, everyone. Thank you for including Article 12 in today's panel. We'd just like to echo what everyone else has been saying. We're fully supportive of the proposal to incorporate the UNCRC into Scots law. It's something that we've been campaigning on for some time, and we believe it's the most important thing that we can do to ensure all children's rights are respected and protected, and demonstrate that young people have the same human rights entitlements as adults. This is particularly concerning at the moment due to the issues arising from the COVID-19 pandemic and indeed Brexit. We commend the government's commitment to ensure the participation of children and young people remains an underpinning principle throughout its process through Parliament, and indeed when it's enacted. This is the only way that full and meaningful participation of children and young people will be at the heart of all policy and practice. We would ask that the committee considers that the bill provides for the robust monitoring of all practices, and if it does, we would recommend to Parliament that they will put that into place. We don't envisage any difficulties with the incorporation model but we do believe that it should be viewed as a minimum framework and a baseline which can be continually held to account and built upon to create the gold standard which will protect and give a voice to all Scotland's children and young people. And we will be scrutinising the impact at national and local levels. Thank you.
Thank you, Beth. Susie, if I could come to you now, please.
Thank you very much for inviting Inclusion Scotland along today. Just to reiterate and back up much of the evidence that you've heard this morning, Inclusion Scotland fully supports the maximalist approach of the incorporation bill, directly incorporating UNCRC requirements within the competence of the Scottish Parliament and making it unlawful for public authorities to act incompatibly with the UNCRC. I think it's important just to reiterate that disabled children's rights are obviously contained within the Convention on the Rights of the Child, but their rights as disabled people are also contained within the UNCRPD. And I should say explicitly that Inclusion Scotland believes strongly that UNCRPD rights also need to be incorporated into domestic law if we are indeed to respect, protect and fulfil disabled children's rights. Disabled children consistently face additional barriers in pursuing remedies for breaches of their rights, inadequate resources, barriers that directly relate to their impairment, such as a lack of communication support. I know that independent advocacy has been stressed by many of the contributors in the first session, and we would echo the need for independent advocacy that is actually accessible to disabled children, accessible information, knowledge of their rights, and very importantly, disabled children are often reliant on others to act on their behalf where capacity is an issue. So we believe that incorporation is a vital first step, but disabled children must be able to access and trust the legal system to protect and enforce their rights. And they must be able to obtain a quick, effective and fair response. As such, the ability to take public authorities to court has several positive effects, which I can talk about in detail. And obviously, the pressing need for incorporation couldn't be clearer at the moment. Disabled children's rights are at risk at the moment during COVID-19, and I'd like to refer to some evidence that we have in this regard as we continue the questions.
Thank you, Susie. And Afrika, please.
Hi, good morning, everyone. Thank you for having Intercultural Youth Scotland here. First of all, Intercultural Youth Scotland and the anti-racism pro-black ambassadors do fully support the UNCR incorporation. I think, though, that it is important to just examine
I'm sorry.
The events that
Sorry, can I just pause you there? We seem to be having some difficulty with your connection.
Lives Matter. Oh, are you able to hear me better now?
Yeah, I think we can hear you better now, but if broadcasting drops the video, sorry, right from the beginning, we sort of lost you, if you wouldn't mind.
No worries. Can you hear me now? Is that?
I can.
Better?
You're nice and clear.
All right, thank you. Sorry, as I was saying, the Black and POC community have not only grown up with structural racism that has basically seeped its way through the pandemic, and they have also been dealing, with the murders of innocent Black people and the surge of the Black Lives Matter movement. And really this year, in tandem, it's shone a light on some of the oldest, deepest inequalities of our society. Inequalities that have continued to persist for generations, and a crucial part of this injustice is due to a lack of accountability across many groups of institutions. So we believe and support the bill, absolutely. It has really great mechanisms that are able to hold local authorities and public-facing sectors accountable. in protecting the rights of young Black and POC children, and it has great potential to be a real force of good and power, even justice. But with any policy, and has been something that has been experienced by the Black and POC community, it comes down to consistency of implementation and quality of implementation. To enable true access to rights, we first must dismantle the systemic barriers that withhold them. Thank you.
Thank you, Africa. Some panel members have touched on this, so if you have already, don't feel you need to reiterate. I suppose I just want to hear some reflections. Clearly, the pandemic's highlighted and exacerbated inequality that's existed before it. So, if you have anything further to say on how you think the bill might lead to a better realisation of all children's rights, that would be helpful. I'd also like to ask you about what guidance you think public authorities need to ensure that they meet the duties set out in this bill. And if I could come to Una on those questions first, please.
Yep. So I think in answering this question, I'd like to first outline some of the fact that children and young people with learning disabilities in Scotland face a number of human rights violations. And I think we could talk quite extensively in regard to what those look like. To give some examples, and I think one of the more shocking factors is around the avoidable death of children and young people with learning disabilities. And the recent research from the Scottish Learning Disability Observatory, which has shown that premature mortality was 12 times higher for children and young people with learning disabilities, and 17 times higher when this was girls with learning disabilities. And I think this is deeply concerning given the ongoing coronavirus pandemic and the evidence that we've seen around the experience of people with learning disabilities during this time and the higher mortality rates. Another example would be the use of restraint and seclusion for children and young people with learning disabilities. A recent survey conducted by the Challenging Behaviour Foundation and Positive and Active Behaviour Support Scotland found that 88% of the 204 respondents to their survey said that their disabled child had experienced physical restraint, and 35% said that this took place frequently. In addition to this, we would also want to highlight the inequality of opportunity faced by people with learning disabilities. I think a good example of this is in 2016 and 2017, only 9% of young people with learning disabilities achieved a level 6 qualification or above, compared to 60% of all other pupils. I think this figure is representative of the many stories we hear from children and young people about their lack of school support. I think this came through really strongly in the session that we facilitated with a number of young people with learning disabilities, in which we heard about circumstances in which a young person was being undermined by school teaching staff because of their disability. I think it's also important that we recognise that this inequality of opportunity also extends to lack of opportunities to form meaningful friendships and relationships. This is often because of a lack of relationship education and support to make and maintain friends. Again, I would refer back to our previous session where committee members heard about from a young person with a learning disability about not being able to go out with friends because they didn't have the one-to-one support that they would require for that, and as a result they weren't often invited to things because their mum would need to attend with them. I think for more information regarding that, SCLD have published a report on relationships, which I think is really important in highlighting some of that. I think coming back to the points made earlier, the way that we would feel that this would be best addressed within the bill would be around an overarching amendment to the Children's Rights Scheme to make additional arrangements for children with protected characteristics, including learning disability and those in vulnerable situations. I think there's a precedent for the wording of vulnerable situations, for example, UNCRC General Comment number 14, which uses the language of a vulnerable situation. And as Carly said earlier, we think this would account for children who may not be included under protected characteristics, such as care experienced children and young people. We would also look for Section 3 of the bill on the Children's Rights Scheme to ensure specific commitments to these groups of children.
I'm sorry to interrupt you. I'm just going to pause you there because I know that colleagues will want to probe you further on those sort of specific sections of the bill. I wonder if you have any reflections on what guidance you think is required for public authorities.
guidance would be really welcome on working with children and young people with learning disabilities and what that would need to look like. I think in particular for working with children with profound and complex learning disabilities, and actually about how we can make sure that they are getting the information that they need about their rights in a way that is accessible and understandable to them and their families where capacity may be an issue, and that they are supported to enact and enable those. And I think that's something that over time SCLD would be more than happy to input into moving forward.
Okay, thank you. Beth, can I bring you in on my question there around the guidance that public authorities might need to ensure that they meet the duties?
Yes, Article 12 has consistently recommended in the past that a suite of trainings and awareness raising events at all levels for all those who have or indeed work with and for children and young people, and particularly marginalised children and young people, are required. We believe these should be ongoing during and following incorporation, and that children and young people and those advocating for them should be at the heart of the design and delivery of this. Wider inequalities have a significant impact on the rights of children, the rights of children and young people. As an example, the structural inequalities are a continuing barrier for young Gypsy travellers, principally their lack of opportunities that recognise their contributions as active citizens. As an example, what we found is digital inequality has been a huge issue during the COVID-19 pandemic. It's long been an issue for children and young people from marginalised groups. The pandemic has really highlighted just how much of a barrier to participation this is. So in order for children and young people from these groups to fully participate in consultation and the shaping of the bill, we think this needs to be addressed. The digital inequality is particularly prevalent with children and young people living within the Gypsy traveller community. We also have some issues, which may be for another question, of how there will be scrutiny of the media's representation of marginalised groups of children and young people, particularly young Gypsy travellers. This is one of the key drivers in the inequalities that they face. Thank you.
Thank you, Beth. Susie, that question on guidance, please.
So just to quickly reflect on the current context, during lockdown, many of the services that disabled people rely on to support their daily living, like social care support, physiotherapy, occupational therapy, speech and language therapy, pain management provision, child and adolescent mental health support, and additional support for learning when in school, have been reduced or stopped because of lockdown or tiered restrictions. We conducted research with 800 disabled people across Scotland, including parents and carers of disabled children, and we have found that social care in many cases has been completely reduced or removed, sometimes overnight and without warning. So this has been particularly extreme for children with complex support needs, or when service closure has meant a disabled child or young person who was previously in residential care or supported accommodation has actually had to return to living full-time in the family home. So I'm talking about this in the context of guidance for local authorities because and other public bodies, because what we're actually seeing at the moment is, despite very positive commitments from the Scottish Government taking a child rights approach to the pandemic, we're actually seeing rights at risk. So what I'm saying is that we need to have guidance around UNCRC implementation that actually reiterates connections and the interrelationship between the range of rights that disabled children have. So they don't just have rights under the UNCRC, but disabled children have rights under the UNCRPD. And even before, hopefully, we incorporate the UNCRPD, we need to have guidance that looks at the broad range of rights for disabled people. public bodies need to have training and there needs to be a kind of programme of awareness raising about disabled children's rights. We need to make sure that work with disabled children is conducted in a way that is accessible to them, that information is accessible about rights, because disabled children can't exercise their rights if they don't know about them. I would echo Una's point that public bodies need support to work with disabled children with profound and complex learning disability. There needs to be guidance around working with children who lack capacity to understand their rights, particularly when breaches of their rights are as a result of inaction, neglect, or actual abuse by the range of professionals who actually support them, because those situations are exceptionally challenging to deal with. So in short, I would like to see a suite of guidance for public authorities that allow them to work in a way that respects disabled children's rights.
Okay, Africa, if I could bring you in, please.
Hi. So in terms of supporting and the guidance of young Black and POC people, for the bill to reach its fullest potential, we need meaningful and genuine participation of Black and POC young people at the heart of decision-making tables before any decisions have been made that affect their future. So that's in reference to any body that provides a service to young people and children. There has to be ensured consultation with groups of young people in safe spaces. Really what the ambassadors had kind of their main feedback on this was that education is key, and that it needs to be an emphasis on more resources within education for children and young people to access their rights. Because within education, we can ensure that fundamental knowledge of cultural backgrounds, anti-racism and awareness of not only themselves but others can be instilled. And this is a focus that kind of needs to be implemented on a national level, not just towards children and young people, but those that work with them and surround them. We need to ensure that parents and families have access to these resources too, so they can support their children in knowing and accessing their rights. And this is really part of empowering children to have these difficult kind of conversations from a young age, but ultimately is part of protecting them and instilling the knowledge of their own rights in them. So to ensure children's rights are respected by government, schools, hospitals, police, and alike, as I was saying before, we just have to implement action that works to dismantle these institutions of systemic racism and bias, which obviously withholds so many of their rights. Because an awareness and rich understanding of young people's intersectional characteristics is required to be able to truly respect them. And our institutions that need Black and POC consultation and training in a goal to broaden the reach of facilities used to involve young people, to make sure young people that are often less heard do have a chance. But thank you. That's all I have to say.
Thank you, Africa. Alex Cole-Hamilton, please.
Yeah, good morning to the panel. I'd like to ask the same questions I did to the first panel, and that the UNCRC is a living document and is added to every year with the general comments, with concluding observations, UN rapporteurs and optional protocols. Do you think that Section 4 on the interpretation of the UNCRC requirements should be expanded to take account of those living aspects of it, to the general comments and the concluding obs, and indeed other opinions in international human rights treaty? And could there be unintended consequences if the bill were amended in this way?
Thank you, Alex. Una.
Yeah, I think in a nutshell, we would agree with that. To give slightly more detail, we would like to see an amendment to the interpretation of the UNCRC requirement in Part 1 for the bill for the court to consider general comments from across all UN treaties, in particular the UNCRPD, as well as comparative case law, other treaty body jurisprudence and relevant reports from general discussions. We would also welcome a similar amendment being made to Part 3, the Children's Rights Scheme for Scottish ministers to consider the broader general comments. For us, that would be of particular importance would be the Committee on the Rights of Persons with Disabilities. We believe this is critical for a number of reasons. General comments are recognised as authoritative guidance and have been by the Supreme Court on several occasions. We believe that this will ensure that children and young people with learning disabilities, alongside other protected characteristics, see themselves in this bill. We think that without this, a child or young person with a learning disability may not recognise this legislation as relating to them or as helpful to them in realising their human rights. We also believe that it will help to ensure the various rights violations facing children and young people with learning disabilities in Scotland. And going back to Susie's point, that bit of considering children and young people with learning disabilities not only as UNCRC right holders, but rights holders of the UNCRPD. And we think that by ensuring that the general comments are included within this bill and that there's a duty to look at them, we think that that would help to future-proof this bill where there is a move to incorporate the UNCRPD in future. Thank you.
Thank you, Una. Beth, please.
Yeah, I think that keeping the bill live will allow for any developments that happen at the international level, keeping children and young people's rights at the forefront of all future development and decision making and policy and practice. This would help to, as people have previously mentioned, future-proof any future legislation that may not be compatible with the UNCRC. Thank you.
Thank you, Beth. Susie.
So just to reiterate what Una has said, we would agree with SCLD that currently the bill provides that the courts may consider certain material when interpreting the UNCRC requirements. So while this direction is welcome, like many other contributors today, we believe that it misses the rich and valuable guidance provided in other UN committee documents, such as general comments, concluding observations, opinions made in relation to the third optional protocol, and reports resulting from days of general discussion. We believe that these documents serve an important role for disabled people and disabled children in particular, both in clarifying the content of UNCRC rights, particularly with regards to Articles 2 and 23, which directly relate to disabled children. They outline potential violations and they offer advice on how best to comply with UNCRC obligations. But we also believe that we need to make reference to the UNCRPD, direct reference to that, and we would encourage the committee to consider broadening Section 4 to provide that the courts be encouraged to take account of these critical sources, and they take the widest approach possible to ensuring that disabled children's rights are upheld.
Thank you, Susie. Africa, please. Seems like we may have lost connection to Africa, so I'll go back to Alex and we can pick up again when we manage to reconnect her. Alex.
Thank you, Convener. Yes, I'd just like to ask about commencement again. And obviously, we're still waiting for the last Children's Rights Bill this Parliament passed to be implemented because it didn't have a commencement on it. Do you believe that this bill should have a clearer defined start date? And if so, when do you think that should?
Una, please.
Thanks. Yeah, and not to labour the point, because I know that many of the other members this morning discussed this, but I think we would support a speedy commencement to the bill, as we don't believe that the rights of children and young people with learning disabilities can wait. I think that's most clearly illustrated in the evidence we presented around be higher rates of mortality for children and young people with learning disabilities. We would therefore support the bill being commenced as soon as possible and up to 6 months after being passed. Thank you.
Thank you, Una. Beth.
Just to echo what other people.
I'm sorry, Beth. Can I ask you to repeat that? We didn't quite catch.
Hi, sorry. Just to say, Article 12 in Scotland would support the commencement of the bill as soon as it's humanly possible. We don't think that there can be any delay to this happening, particularly given certain current circumstances at the moment. Thank you.
Thank you, Beth. Susie, Alex's question there about commencement, please.
Just to reiterate, given the pressing need for incorporation and all potential levers to advocate for disabled children's rights at the moment, we believe commencement should be as immediate as possible, really. We understand that public authorities and public bodies are under extreme pressure at the moment. We understand that the Scottish Government's under extreme pressure at the moment. I think it's even more important in this context to have commencement by the latest at the end of 2021. So we are just in support of the comments that have been made on commencement in the first evidence session and just now.
Thank you, Susie. And broadcasting are still trying to connect Africa, so Alec, can you give me a nod of your content for me to move on to the next questions? Thank you. Mary Fee, if I could bring you in, please.
Thank you, Convener, and good morning, panel. And I would like to ask the same two questions that I asked to the first panel, and I'll roll them into one because I'm conscious of the time, and it's around the duties and the definitions of a public authority. So the focus the government has put in this piece of legislation is to focus on a duty not to act incompatibly, and they're not taking a dual duties approach. Is that something that the panel agree with? And my second question is around the definition. And I'd like to ask if the panel are content with the definition of a public authority, which is set out in section 6, or would you like to see changes made to that definition? Thank you, Convener.
Thank you, Mary. Una, if we could come to you first, please.
Thank you. I'm going to keep my answer to this question brief because I think it was really well covered in the first session. In our initial consultation response, we supported the compatibility duty alongside the addition of a due regard duty. We thought that this would best ensure both the reactive and proactive measures of the bill. We also said that we believe that Article 23 regarding disabled children should be used as a framework for effective and policy and decision making, rather than only the basis for taking legal action. We said that we believed that this would help to ensure the needs of children and young people with learning disabilities are considered at early stages in decision-making processes and protect them from the risk of rights violations, which we know that they experience frequently. In saying that, as this is an ongoing process, I think it's important that we would also echo Juliette's points about the other options in which this can be achieved. So, for example, through the children's scheme and through public bodies reporting duties. I think it would also be important that this was achieved through making sure that children and young people with learning disabilities are visible in the bill and obligations regarding disaggregated data on disability. Thank you.
Thank you, Una. Beth, please, questions around the duties on the public authorities from me.
Sorry, I'm having trouble hearing just now.
Beth, Mary Fee's question was about the definition of a public authority as it's set out in section 6, and her question was around if you felt that needed to be expanded on.
Okay, we think it's important to include all organisations, groups and services within this definition to ensure that all children and young people receive the same protections across the board and to ensure equal provisions. We think that if this doesn't happen, then it could lead to patchy provisions from those who are working with children and young people. We really need to ensure that their rights are built into all practice and delivery, decision making and delivery. Thank you.
Thank you, Beth. We heard that loud and clear. Susie, could I come to you on Mary's questions then, please?
So, first, in relation to the due regard duty, perhaps a due regard duty would improve the bill, and we would be interested to find out more about that, actually, in relation specifically to the rights of disabled children. So what a due regard duty would actually mean for disabled children and young people trying to exercise their rights, and whether or not it is significant enough to advocate for. We would agree that additions to the children's scheme may well serve the same or a similar purpose, particularly the need for a public body reporting duty that makes reference to the need to report on how disabled children's rights are being upheld. I know that the issue of disaggregated data has been raised before, and we would agree that public bodies really need to break down how their actions actually impact on disabled children and young people. We would like to see disabled children and young people participating and being involved in the production of the children's scheme. In relation to the definition of public authorities, this is a very important point for disabled children. They're impacted by the decisions and actions of private housing providers, residential care providers, private childcare providers, private foster care and public schools. For example, their rights can be directly breached by poor or negligent practice in relation to seclusion and restraint within private childcare provision. There's very patchy provision of adaptations in private housing, or privately rented housing, I should say. There's poor physical access in schools, and poor provision of additional support for learning in certain cases in childcare settings that are provided by private companies. So we're keen to seek assurances that such organisations will be included within the scope of this duty, and that private bodies will not escape liability should disabled children's rights be breached. The UN committee itself recognises the role that private actors play in the delivery of children's services, including education, transport, health and alternative care. So we would like clarity on the definition of public authorities and assurances that the bill will make sure that disabled people's children's rights are protected in these settings.
Thank you, Susie. Mary, are you content, or do you have any follow-up?
No, I'm content. Thank you, convener.
If I could bring in Gillian Martin, please.
Thank you, convener, and good morning to everyone. If you were watching the previous panel, you'll know that I mentioned the issue about accessibility to the judicial system and courts, given that there's not going to be a new judicial body. I want to ask everyone if they think, first of all, that courts, tribunals are accessible to children as it stands, and if not, what changes you think should happen ahead of the incorporation of the UNCRC.
Una, if we could come to you first.
Hi there. I think for us, the thing that would be kind of first important to recognise is that for many children and young people with learning disabilities and adults with learning disabilities, courts are not accessible to their needs. We highlighted that in our initial response in regard to evidence around challenges that children and young people can face in regard to accessing justice For example, a lack of accessible information on taking legal cases, attitudinal barriers about their ability to take those cases, and a lack of specialist awareness on learning disability from legal professionals and within the courts. I think in recognising that, we would see that there's a role for those in the learning disability sector to be able to link children and young people with learning disabilities to legal professionals to be able to take cases, and we think that that is a gap in terms of the provision. I think we would also, as others did earlier, highlight the importance of advocacy and the relationship-based practice within that, and would highlight the need for training for courts on disabled people's rights, and particularly the needs and aspirations of children and young people with learning disabilities. Thank you.
Thank you, Una. Beth, Gillian's question was about the accessibility of existing courts and tribunals to children, and what changes might be required to make them more accessible, whether that's in the bill or more generally. Please.
Hi. Yeah, we endorse the preventative approach to any rights breaches via the Children's Rights Scheme, impact assessments and reporting duties on public authorities. We believe that incorporation will have a positive change on the perception of children and young people as rights bearers, and this will create a safety net around their rights and informed decision-making policy. Implementing the UNCRC will hopefully lead to less of a risk of rights being breached in the first place. However, Article 12 welcomes the provisions of the bill that enables the courts to assess the compatibility of legislation with the UNCRC and for children and young people and those who seek to represent them to challenge any breaches. Where it's not possible or appropriate for children and young people to raise complaints, we welcome the powers granted on the Children and Young People's Commissioner to act on their behalf.
Thank you. Susie, please.
So again, just to support points particularly made by Una, there are long-standing barriers to accessing justice for disabled children and young people, particularly accessing the court system. Understanding how to navigate the system, knowledge of the law, financial costs, particularly for disabled young children taking cases, because sometimes they have to provide a fairly costly report into the nature of their own disability, and that can be a legal hurdle even when legal aid is provided. I think it's important to understand that many disabled children and young people and their families live in poverty, and that is the context to which many children and young people will be contemplating kind of entering the court system. I think I would echo the points from the first session about the need for parallel processes to ensure that disabled children's rights are enforced without having to go to court. So going to court should really be looked on as a last resort, not a primary mechanism for giving effect to CRC rights. We would like to see a system of child-friendly and accessible complaints procedures, as has been already reiterated. At the moment, the bill doesn't currently provide for that. The UN committee has emphasised the importance of independent complaints procedures and child-friendly information, as well as access to independent advocacy, which again has been highlighted by lots of contributors, and Inclusion Scotland would agree with that. The need for independent advocacy is key. So we'd urge the committee to consider how provisions in this regard can be strengthened in the bill. For example, an amendment that adds an additional requirement on Scottish ministers to set out a process for child-friendly and accessible complaints within the children's scheme.
Thank you. Susie, I understand that Africa is reconnected, so I wonder if I could put Julian's last question there to her, and we'll catch up by correspondence on the ones that we missed. Julian's question was about part 2 of the bill and the vision that existing courts and tribunals rather than a new judicial body would authorise judicial remedies proposed in the bill. and the question was whether these existing courts and tribunals are accessible to children and young people, and what changes you might suggest if they're not, and whether that be in the bill itself or more generally. Africa.
Hello?
Hi. Did you catch the question?
Hi. Oh, just barely. The connection is so bad. I'm so sorry for the inconvenience here. I think there must be a real issue with it.
It's not inconvenient to us at all. I wonder if it might be more helpful if we catch up by correspondence. I appreciate the pressure.
I think so. I think it's quite disorientating coming in and out and just hearing bits and bobs. I would really love to hear everyone in full and the questions as well. So if that's possible, I'd really appreciate that.
It absolutely is. And we had a very good session with Intercultural Youth Scotland ambassadors, so got a wealth of information from there. But the committee will follow up on the specific questions so that you have an opportunity to answer them fully. I appreciate how stressful it is popping in and out in this wonderful technological platform that we're using. So thank you for persevering, Africa, and we'll be in touch in a different way.
Having me. I'll look forward to seeing you later. Bye. Thank you.
Thank you. Okay, so Gillian.
Yeah, and off the back of what we just discussed around the inaccessibility of courts, I asked the other panel about child-friendly complaints processes in other public authorities, and whether I think I know the answer because certainly there was quite a comprehensive agreement with the last panel, but whether you think they exist, are they child-friendly, and what should be done to make them child-friendly, if not?
Okay, thank you, Gillian. I see that Beth was wishing to come in, so if I can bring you in now, Beth.
I know it's okay. What Gillian's just asked covers what I was going to say, so I'll let you get back to the...
Feel free to. That's okay, Beth. We can take your answer on that at the moment.
Okay. I was just going to say that I think it's important that children and young people are able to rely on the UNCRC to protect their rights within the legal system. However, any complaints mechanisms should be ensured to be child-friendly, independent, accessible, and jargon-free. Help, support and advocacy must be in place to help children and young people to assert their rights. Early intervention will obviously be useful for stopping any issues before they really start. It's important that children and young people know how to access this support, so there should be quite a child-friendly model put into place. We also think that children and young people should be empowered to self-advocate where appropriate too. And we would like to look to the international community for guidance on this. Thank you.
Thank you, Beth. Una, can I bring you in on Gillian's question around child-friendly complaints process?
Probably not surprisingly, I think we would echo the points the earlier session in saying that we're not aware of particular child-friendly complaints mechanisms for children and young people with learning disabilities. I think it's important to acknowledge that we often hear from families where the child has a learning disability that if you want to get anything done or if you want to have your child's rights met, you have to have a parent who's willing to fight for you and who has those capabilities. And I think it's in looking at the child-friendly complaints mechanisms, it's about how we can level the playing field so that all children and young people have that same access. I think in terms of how those processes are developed, I would suggest that we learn from the wider learning disability sector. I think people who work with people with learning disabilities have over years developed really good and effective ways of accessible communication and including and involving people. So I think there's a potential to learn from that already existing sector. Again, I would highlight the need to support this with human rights education for children and young people with learning disabilities and their families, because I think one of the largest barriers in accessing complaints is firstly not knowing that you have those rights and entitlements, because for so long you've been kind of put down and put aside. So I think that's of critical importance. Thank you.
Thank you, Una. Susie, you mentioned in your previous answer child-friendly complaints process. I don't know if you have anything further to add.
Just to really support what Una said there, we're not aware of a great body of best practice, if you like, in relation to child-friendly complaints that are actually accessible and suitable for disabled children, particularly disabled children with learning disability. And we would agree, we'd just echo those points about the need to involve the wider sector in this, so particularly disabled people's organisations, I would say, who have a whole kind of body of experience from years of engaging with disabled children and young people, providing information in accessible and child-friendly ways. And I think there's a really real opportunity here, if we are committed to rights education on the back of the Incorporation Bill, and we are committed to a process of public education, and I think that goes hand in hand with parallel processes, really, and the need to set up complaints mechanisms. I mean, our pressing concerns for disabled children and young people at the moment in terms of their rights are things like social care being removed, and there is very little, there are very few processes in place where disabled children can actually make effective complaints about things like that. So things that dramatically affect their everyday lives at the moment, there aren't child-friendly mechanisms for them to do anything about those things.
Thank you. Gillian, if you could just give me a nod if you're content with those answers and for me to move on. Thank you. Can I bring in Alison Harris, please?
Yes, thank you. Morning. I would like to ask about court proceedings. Section 10 specifically empowers the Children's Commissioner to raise court proceedings in respect of the duty on public authorities. More generally, Section 7 of the Bill says an individual or organisation can raise court proceedings in respect of this duty. In practice, usually for a judicial review proceedings, litigants will also be required to demonstrate sufficient interest. Are you happy with this overall approach, including how the government's policy intention is given effect to the wordings of Section 10 and 7 of the Bill?
Una, please.
I think, again, to echo the points of the earlier session, we welcome the Commissioner's role. What I would want to say, and this goes back to Carly's earlier point, is around other organisations with sufficient interest bringing cases. I really do think that there is a need for learning disability organisations, and as Susie mentioned, wider disabled people's organisations around capacity building to bring these kinds of cases where appropriate. I think there's to an extent, the learning disability sector and wider sectors have maybe been kind of left behind to a certain degree on these, on how to achieve that. So I think there would be a real need for upskilling of the current sector. And it goes back again to that earlier point about where there might need to be intermediary organisations to link people into legal processes, because I do think that there's quite a big jump from having your rights breached and dealing with that in every day-to-day life, and then taking a case, and actually there might need to be a process in which that's achieved. So really around capacity building to bring cases and to educate and inform children and young people about their rights. I believe these suggestions are in line with the UNCRC General Comment number 5, which says that children's special independent status creates real difficulties for them pursuing to their rights, so that states need to give particular attention to ensuring that there are effective child-sensitive procedures in place. Thank you.
Thank you, Una. Beth, if we could come to you now, please.
Hi, just to echo what's already been said, we welcome that cases can be brought through the Children and Young People Commissioner, and we're supportive of the exclusion of the victim test. also. We also believe that third sector organisations are very well placed to work with and for marginalised children and young people to provide advocacy. Obviously, some sort of training would need to be in place to ensure that this is done to the best practice. Thank you.
Thank you, Beth. Susie, please.
So, yes, in relation to Section 10, excuse me, like everyone else, we welcome the provisions that allow the involvement of the Commissioner. That lever has been extremely significant for disabled children and young people in the past, particularly with the Commissioner's investigation into things like seclusion and restraint, which has been a long-standing issue for disabled children and young people, particularly children with challenging behaviour and additional support needs and complex needs. Whilst it had been known about for a long time and individuals had and parents had been raising those issues, there hadn't been an effective remedy and there hadn't been an effective route for redress. So the involvement of the Commissioner and the investigation into seclusion and restraint was a very powerful lever. So we would support the provisions that relate to the involvement of the Commissioner in the bill. Section 7 in relation to sufficient interest. Inclusion Scotland is actively seeking to support disabled people, including disabled children, to access their rights. So we've formed a partnership with Just Right Scotland to form the Scottish Just Law Centre, which aims to tackle discrimination and policy and practice via strategic litigation. So we believe that strategic litigation is an important avenue to protect and fulfil disabled children's rights. And in this context, we would recommend that the committee seek clarity on the provisions within the bill that relate to standing to ensure that the bill definitely achieves its policy objective of removing barriers to disabled children's access to justice. We welcome the removal of the victim test, but we're seeking clarity that will enable organisations like Just Right Scotland and Clan Law and other organisations that support parents and carers and individual disabled children to bring cases that if these cases were deemed to have sufficient interest, that the current bill would allow that linkage to be made.
Thank you. Alison.
Okay. So if we look at the time limits for bringing court proceedings, the committee has received written submissions offering mixed views on whether it is correct to exclude the period when a young person is under 18 when calculating the time limits for raising court proceedings under Section 7 of the bill. Would you like to comment on this issue or the approach to time limits more generally under Section 7 of the bill?
Una, please.
I'll keep my answer brief because I think it was really well covered in the first section. I think it'd be important to say that we would really support Juliette's earlier point about the evolving capacity of children and young people, and particularly those with learning disabilities, so around having that time limit extended so people can bring cases at a later date. I think, and we would also echo those points around children and young people not feeling able to raise things, or families not feeling able to raise things because they might feel that it has an impact on the care and support they receive, which we know for children and young people with learning disabilities is very intertwined in their day-to-day life. So I think we would just welcome all those points from that earlier session and support them. Thank you.
Thank you, Una. Beth, please.
We would be very supportive of this as well. Vulnerable children and young people and their families, they may not have the confidence or the capacity to bring cases as they happen. So this is crucial to ensure the accessibility of this for all. We believe they should be able to bring cases as they feel ready, not just as it happens.
Okay, thank you. Susie.
Yes, we would agree with previous contributions and submissions in the first evidence session around timeframes for starting proceedings. disabled children and young people are often exhausted by the systems they're around that enable them to exercise their rights. They're inaccessible, occasionally underfunded and disconnected from each other, and are difficult to navigate. We are concerned about the meaning of the term "the Act" in Section 7, subsection 1A. Essentially, what we're concerned about is if this term relates to the assessment and the determination of an award of support to a disabled child, and the assessment takes place before Section 7 comes into force, then we're concerned that disabled children and young people won't be able to take proceedings. We can maybe provide a bit more detail on this to the committee at a future date. I can come back with a more detailed submission on that if that would be helpful.
Thank you, Susie. Yeah, I think that would be, and I would say we do have the Deputy First Minister in front of us next week. So if it was at all possible to have it before then, that would assist the committee. Alison, are you content for me to move on to colleagues? Alexander Stewart.
Thank you very much indeed, Convener. If I can go back to the questions I was asking of the first panel, which was with reference to the Children's Rights Scheme. And as we indicated, there are some concerns that it isn't strong enough, that the language needs to be much stronger in some of the respects as to what it's trying to achieve. So can I ask the panel for their views on that? And is there anything that should be added that would ensure that the scheme did become much stronger in the responses?
Thank you, Alexander. Unava, come to you, please.
Yeah, there's a number of things that SCLD would welcome to strengthen the scheme, and again echoing the earlier points around strengthening of language, which I think has been relatively well covered. For us, I think one of the main things that we would want to see within the scheme, and I think Juliet raised this earlier, was around human rights education for disabled children and young people, and in particular children and young people with learning disabilities. Because as we've said in earlier sessions, that young people with learning disabilities very often don't know about their human rights and how to enact them. We would also, I think it would also be important in regard of strengthening the scheme to make sure that we have included data disaggregation for children and young people with learning disabilities. We believe that without this, it will be challenging to understand whether children and young people with learning disabilities are having their UNCRC rights fulfilled. We believe that this will further contribute to people with learning disabilities' invisibility in published statistics. We would therefore look for a strengthening about this regarding the children's scheme and for public authorities in Part 3. We believe that this should include protected characteristics which are disaggregated, for example, disability, including learning disability and physical impairment. We believe that this should provide details on the number of children and young people with learning disabilities receiving human rights education, access to advocacy, child-friendly complaints and processes. We believe that this is in line with Article 31 of the UNCRPD and should therefore be considered as a priority issue to ensure compliance with that treaty as we move forward. Thank you.
Thank you, Anna. Beth, can I come to you now, please?
Yeah, we were very happy to see a strong stance on young people's participation in this. Introducing a child's rights scheme will ensure the monitoring and evaluation of progress and compliance by all stakeholders. We believe it's important that this monitoring and evaluation is transparent, and reporting annually on this will make it more accessible. It will also enable dialogue with young people around what works and what they think should be changed. This will help not only to embed children and young people's rights into the decision-making process, but also to influence it and ensure their participation and engagement. There's lots of relevant third sector organisations who are well placed to amplify the voice of the young people they work with. We also echo what's been said on sort of changes to the language around the scheme. Another point is what's already been raised is we think it's important to ensure all children and young people have access to rights-based education. As an example, during our last reporting process and our work with young Gypsy travellers, none of them had heard of the UNCRC prior to their involvement with Article 12. So it's vital that all marginalised children and young people, particularly groups like Gypsy travellers who experience difficulties in access to information and participation and so on, are meaningfully engaged in decision-making processes. Thank you.
Thank you, Beth. Susie, please.
So just to echo previous points made in the first session about language within the bill in relation to the Children's Rights Scheme. So we obviously welcome the inclusion of a Children's Rights Scheme, but we note that the duty to prepare the scheme under Section 11, subsection 3, does not set requirements for its contents. So it doesn't say what should be in it. It instead provides that the scheme may include arrangements to ensure children's participation in decision-making, awareness raising and rights-based budgeting, but we believe the language should be changed from a may to a shall, so that we're sure that the language on that within the bill to ensure children's participation and obviously disabled children's participation is as clear as it can be. We welcome the duty to consult with children and young people and the Children and Young People's Commissioner and other stakeholders within Section 12. We're adamant that disabled children and young people must be properly involved in the development and the review of the scheme, and to kind of ensure this, we'd urge the committee to consider an amendment for all of the scheme to apply, as Una has said, for children with protected characteristics and also those in vulnerable situations. So I think that point's been quite clearly made by Together in the evidence session this morning, so we would support that.
Thank you. Can I go to Fulton McGregor for his questioning, and then we can come back and talk about resources. Fulton.
Thanks, Convener, and good morning, panel. Similar to the panel before you, I want to ask about the children's rights and wellbeing impact assessments. So firstly, I suppose the question's in two parts. What are your views on the impact assessments generally, and more specifically, what are your views on the legal duty on Scottish ministers to prepare these assessments for legislation and for decisions of a strategic nature? And do do you think the ministers should have this discretion?
Thank you.
I'm happy with the.
Okay, thank you. Una.
Again, supporting earlier points, we believe that the children and young people's wellbeing assessments are important and valuable tools, and we support ministers having a duty to complete those as part of the children's scheme. As we stated in our response, SCLD also welcomed a commitment for the conducting of children's rights and wellbeing impact assessments being extended to all public authorities. I think it's important that we say that over time we've become increasingly concerned with the quality and low uptake of equality and rights-based assessments across the board. In practice, we've seen this leading to the negative lived experience of people with learning disabilities whose needs are often not fully addressed in these processes. I think when we look at the experience of children and young people with learning disabilities being restrained and excluded in schools, which in particular includes an individual story we recently heard of a young person with complex needs who was restrained 30 different times between the ages of 5 and 10 in several schools, we believe these processes are both of value and are needed. We do, however, recognise that this may be a challenge and would therefore accept what Juliet had suggested earlier around public authorities and their reporting illustrating how planning has considered UNCRC rights and its implications. We would also ask for assurances on how public authorities can make sure their work is UNCRC compliant and how this will be promoted across public authorities through training. Thank you.
Thank you, Una. Beth, please.
Yeah, we welcome these. Indeed, we believe they're crucial. It's crucial that all decisions that impact on children and young people should have a duty for an impact assessment. I think it's also important that these do not become sort of a tick box measure if they're going to be meaningful. And they should be published and promoted in a child-friendly format which will ensure accessibility to all the children and young people that they seek to represent.
Thank you, Beth. Susie, come to you, please.
So we are broadly supportive of the provisions in relation to the impact assessments and the child rights impact assessments. I think we are beginning to have a degree of skepticism, if you like, about and probably it's related to what Una said about the quality and the low uptake of the quality impact assessments. And I think the kind of current context for disabled children is really important here. So their rights are at risk, particularly because social care has been removed from them. And we know that the Scottish Government is intent on having a child rights-based approach to the pandemic. And I suspect that public authorities are carrying out equality impact assessments of their responses. But yet, what we're finding is even if these things are in place, that disabled children are still experiencing very significant difficulties with services being removed from them. So I think in this context, while we obviously support the necessity to undertake child rights impact assessments, we have a concern that that alone will not impact on practice and policy in such a way that disabled children's rights are ensured.
Thank you, Susie. Fulton, can you let me know if you have further questions?
Yeah, I did have a second question, Convener, but it was more a summing up one, and I'm happy to leave it to the very end if indeed you think it's appropriate to ask, because I think there's been really full answers so far.
Okay, thank you. Alexander.
Thank you, Convener. I just wanted to go back to the potential we talked about with the first panel, which was about the potential resource implications for the bill. And as your organisations are managing and processing all that, we've heard about all the potential that's done already that has been worked out. But as this new bill progresses, would there be any additional resources that you would see that would affect your organisation or have an impact on public authorities and other third sector groups?
Thank you, Alexander. Una, can I come to you first, please?
Yeah, I think for us, what we'd be keen to highlight is the need for resources being ring-fenced for children and young people with protected characteristics in vulnerable situations. I think, and particularly around human rights-based education. I think that for us, we recognise that that universalism in terms of approach and how we achieve these things sometimes doesn't work for children and young people with learning disabilities, and they end up being left behind. So we would therefore want to highlight to the committee the need for kind of ring-fenced resources for third sector organisations and those working with children and young people with learning disabilities about how they make sure that their rights can be realised and linked into the legal system where appropriate. Thank you.
Thank you, Una. Beth, please.
Yeah, just to reiterate that we think it's important to ensure the funding for organisations that are already working with children and young people from marginalised communities. You know, a lot of us are already in waiting to we're already working with the UNCRC and we're kind of waiting to progress this alongside the bill. You know, a rights-based approach could be seen as a preventative one, looking long-term. If it's properly implemented, it has the capacity to stop a lot of issues before they become an issue, which long-term would be more cost-effective. And I think when we're looking at the future of young people and their rights, I think that finances should be one of the. I know that they are a concern, but I think that they should be at the back of the decision making surrounding this. Thank you.
Thank you, Beth. And Susie, please, that question around resources.
So we have found, particularly on our work to make disabled young children aware of their rights under the UNCRPD, we have found that many disabled people, including disabled parents and disabled parents of children, disabled parents of disabled children, are often completely unaware of their rights. So we would encourage the committee to consider adequate resourcing for public information on these rights, on these convention rights, that are actually accessible and meaningful for disabled children and families of disabled children. We would like the committee to consider amending sections 11 subsection 3 and 13 subsection 3 on the Children's Rights Scheme, so that ministers are required to set out and report annually on what they're doing to ensure independent advocacy for services for disabled children, because that is a crucial part of any public information campaign and support to enable disabled children to actually access their rights, and that is going to take resourcing. We saw, particularly with the work on the social security, on setting up the new social security system for the devolved benefits in Scotland, that a right to independent advocacy for disabled people claiming new devolved disability benefits was recognised by the Scottish Government as actually essential to the kind of running of that system in order to ensure dignity and control and fairness for disabled people. And I think a similar approach to independent advocacy has to be taken alongside this bill. And obviously that's going to have resource implications. As an organisation, the resource implications for Inclusion Scotland are going to be around the cost of engaging disabled children and young people in this process, the need to use resources to provide information in accessible formats about rights and rights entitlement. Additional resourcing is going to be needed to involve the organisations that you need to involve in a kind of public education campaign.
Thank you, Susie, and that draws our second evidence session to a close. I think we've had a lot of good answers and information around areas that can be perhaps strengthened in the bill, and what more we can do to advance children and young people's rights in Scotland. Una, Beth, Susie and Afrika, thank you very much for your evidence this morning, and in particular for your forbearance as we work our way round with the technology. We really appreciate your time and your expertise. Any follow-up scrutiny issues will be dealt with by correspondence, which will be published on our website. So that concludes the public part of the committee's meeting. The next meeting of the committee will be on Thursday, the 3rd of December, where we will take evidence on the United Nations Convention on the Rights of the Child Incorporation Scotland Bill from the Deputy First Minister and Cabinet Secretary for Education and Skills. As previously agreed, I'll now move the meeting into private session, suspend for 5 minutes, and we will reconvene on MS Teams.